Begin the public hearing. And we are now live streaming. Welcome back, ladies and gentlemen, to the public hearings of the Environment and Transportation Committee. I'm the chair, Delegate Kumar Barve. I'm joined by my vice chair, Dana Stein, and much of my committee is filtering in here. So let me first tell you what the order of the bills are going to be, with one little caveat, and they will be House Bill. We're going to be doing this in numerical order with one possible caveat. And it's this: House Bill 464, Montgomery County and Prince George's County delegations; House Bill 789, the Montgomery County and Prince George's County delegation; House Bill 1223, Delegate Lehman; House Bill 1226, Delegate Lasanti; House Bill 1239, that Delegate Learman person again; House Bill 1273, Delegate Conaway; House Bill 1282, Delegate Grammer; House Bill 1283, Delegate Wells; House Bill 1305, Delegate Arentz; and the last bill on the list is House Bill 1325, Delegate Ampry. But I understand that Marlon is going to be jumping back and forth between many committees. And so what I'm going to do is, after every bill, I will ask if we have Delegate Ampry in the House, and if we do, we'll take his bill then so he can scamper off and do whatever else he wishes to do. So with that, let's begin with House Bill 464, the Montgomery and Prince George's delegations. I'm going to assume that's why Al Carr is here. Is that right, Al?
It is.
Okay, you have the floor.
Okay, thank you so much. Good afternoon, Mr. Chairman and distinguished colleagues of Environment and Transportation. For the record, Al Carr here for House Bill 464, and this is a bi-county bill. It passed unanimously in the Montgomery County and Prince George's County delegations. It is identical to House Bill 394 that passed the House of Delegates in 2020. And it has to do with mandatory referral. This is an existing process that's been in the law for decades, and it's an improvement to the process of a complete submission by a government agency to Park and Planning, who is having their project reviewed. I ask for your favorable report.
All righty then. We have a number of people who are signed up to testify on this bill, and only one person is against the bill, and their testimony is written. So let me recognize Deborah Borden with Park and Planning. Oh, and she's the only other person to be testifying. So Deborah, welcome to the committee. You have 2 minutes.
Thank you, Chairman Barve. I'm Deborah Borden. I am the Deputy General Counsel for the Park and Planning Commission. We are the only agency in the state that runs the mandatory referral program in Prince George's and Montgomery counties. And it's a program where we review public projects, government projects, to build build projects, build buildings, build trails, build roads, any kind of building project that is done by a government agency, whether federal, state, or local. We review these projects and we give the agencies our recommendations. It is a way for the projects to be reviewed, not just by us, but by members of the public, by the neighbors and the neighborhood associations that are interested in the projects. It gives them an ability to get detailed information about these projects that are happening in their communities. And it also gives us the opportunity to give our expertise to these agencies that are building projects that may only build, one project every 50 years, as well as other agencies that do this kind of thing all the time. The reason for the bill is just so that we can have a bit more information in the law to point to when we get questions as to why we need a complete application, why it's not good enough to give us a one-pager. And so this sort of just beefs up the legislation, because right now, really, the legislation just says the commission shall do mandatory referral. It doesn't say anything about having a complete application and what that means. So I'm here to answer any questions you might have, and thank you for the opportunity.
Does anyone have any questions? I will have a question, but does anybody else have a question first? Okay, I don't see any. So my only question, Deborah or Al, is I noticed that the Department of Transportation has written an unfavorable, has given us unfavorable testimony. I haven't read their testimony. I was wondering if you had, and if you had, what reaction you have to it.
Yeah, well, I guess I'll start and Deborah can fill in any gaps here, but I'll tell you what the Department of Transportation didn't talk about. What they didn't talk about is, what happens when an agency like MDOT doesn't want to follow the process, and it's an advisory process. It's just a public review. They don't have to change anything in their project, but they will get the benefit of that local input. What happens when the project is not followed is something that happened in my district. MDOT built a salt barn in off of the Beltway in Kensington and Chevy Chase, and they skipped the mandatory referral process because under the current law, it says if a certain number of days go by, your application is deemed approved. And so what happened was they went ahead and they built it, and there are aspects of the project that the neighborhood is very unhappy with, and they're now having to go back and move fences and shield buildings and make these changes that they could have incorporated into the project from day one, but now they're having to go back and retrofit the project. They didn't talk about that, and that's why this bill is important.
Deborah, do you care to add anything to that?
I would just add that, we have been doing mandatory referral for decades now, and we think we're pretty good at it. And we do not use this process as a way to slow down public projects that need to be done, projects that are on a fast track. We accommodate them as much as we possibly can. Our view is, mandatory referral should be a partnership. We should be working with these agencies to try to make the projects as wonderful as they can be, no matter what they are, and to make sure that the communities are aware of what's going on and that they get their questions answered. So we look at this as a way for us to be liaisons, as a way for us to be ambassadors for what we do as a planning agency. And we do really work hard to try to make sure that we are not an impediment to any of these projects.
So I seem to remember this bill now from last year. Is that right? This bill passed the committee last year?
Yes.
That's correct.
Okay, and so it was just a victim of COVID-19, right?
Correct.
Yes.
Okay, yeah, I'm one of those people who's very, very concerned about NIMBYs, and I was satisfied last year that it was okay. So it passes the Kumar anti-NIMBY test. So I bet you didn't know there was such a thing, did you?
That's wonderful.
And if you can unmute yourself.
Unmute me. There we go. Thank you. Yeah. Am I unmuted now?
Yeah, we can hear you.
Wild.
Okay, very good. Thank you. I just wanted to ask if anyone knows the question about that's in the testimony, the written testimony from the Department of Transportation. Has this process ever held up a federal building going in?
No, it can't. We have 60 days to do a review. If we don't make the 60-day time frame and the agency doesn't choose to give us more time, then the project goes forward.
Okay.
There's no way for us to stop a project.
Or even slow it down.
Well, it could be slowed down if the agency, the government agency, doesn't go through the mandatory referral process and they get stopped at permit, and they won't get a permit until they have done the mandatory referral process. So it can slow it down slightly if they didn't, come to us first, and they have to be sent back to go to mandatory referral. Sometimes they don't get stopped at permit, like what happened with the salt barn.
Okay,
And-
I'm just, one of the things I say is that it can hamper getting federal buildings. You know, we're always trying to get federal agencies in our area, and we certainly are hopeful about the FBI, and we certainly don't want to do anything that's going to slow that down. So that's
We
my
have-
question.
Yeah, we have a really great relationship with the federal agencies. They come to us several times with their larger projects. They come to us at the time when they're looking for a good
I just want to
site.
know if this bill is going to hurt that process.
Absolutely not. We
That's
are
great.
very comfortable working with the federal agencies, and they are comfortable working with us. We have never slowed down a federal building, ever.
Thank you.
And
Very
I would just add and reiterate that this is an existing process and it's advisory. So, you know,
got it. Yep.
for public input, the agencies don't have to do what Park and Planning says they want them to do.
Okay, sounds great. Thank you very much. Let's move on to House Bill 789, Delegate Carr. I assume you're here for that one too. No?
I think that's me, Mr. Chair. Delegate Charcutine here.
Oh, Laura, I didn't see you down there. Okay, please go ahead.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. Delegate Lori Charcutine here on behalf of House Bill 789. It's a bi-county bill, Montgomery County and Prince George's County delegations. And this bill is a good government transparency bill. This bill requires the Washington Suburban Sanitary Commission to stream live video of their meetings. And it sets forth a couple of other options if there are problems with technical problems with the streaming process, and then to keep video of the meetings on their website so that folks can go back later and see them. I think that this is something we are now all very familiar with. I think it's a direction that a lot of our agencies, government and quasi-governmental agencies, were headed in anyways. Last year, we passed a number of pieces of legislation over the last few years to require streaming as a way for the general public to stay engaged and aware of what it is that that we're doing in the decision-making bodies, and this just adds WSSC to that process. The other thing that it does is that it adds flexibility in the billing process. It allows WSSC to waive late fees for or reduce late fees when they're providing financial assistance to folks. So we worked with WSSC. I don't know if they've filed here or not, but I believe they are okay with this bill. And then of course, we also worked with both delegations and it has passed through both delegations. I'm happy to take any questions.
Okay, well, Guy Andes is also signed up, so let's listen to him and then we'll
Sounds good.
pointless questions.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. Guy Andes, Government Affairs Manager for WSSC Water. You have our written testimony. Delegate Charcutine explained the bill very eloquently. We thank her for working with us to make changes to the bill that not only meet her legislative intent, but also provide protections in the event of a technical failure on WSSC's streaming of the live open meetings. I'm here to answer any questions you may have. Like I said, we're supportive of the bill that's before you today. We appreciate your support and I'm here to answer.
Get a hold of.
Okay.
Kenny.
Okay, any impertinent pestering questions for Guy Andes or Lord Charcutine? No? Okay, well, that concludes, thank you very much, Laura and Guy. That concludes the public hearing on House Bill 789. Let's proceed to House Bill 1223, Delegate Lehman.
Thank you, Mr. Chairman, and good afternoon, Mr. Chair, Mr. Vice Chair, and colleagues. For the record, I'm Delegate Mary Layman, and I'm asking for your favorable consideration of House Bill 1223. The bill creates new protections for tenants undergoing screening for rental housing, and it specifies conditions under which landlords may not refuse to renew a lease. The COVID-19 pandemic has laid bare inequalities that tenants have endured under rental housing laws. This bill provides screening and lease renewal reforms for prospective and current tenants that are long overdue. First, under the bill's screening provisions, landlords may not deny a lease based on information related to a court record that has been sealed by the court, information related to a prospective tenant's status as a victim of crime or a victim of domestic violence, or an event in a background, credit history, or rental history check that is more than 7 years old. That is what Colorado does, and 7 years is the same time frame under the Fair Credit Reporting Act for exemptions of what information cannot be included in consumer reports. There is a tool for landlords in this bill that allows them to request that a prospective tenant submit a written addendum to a lease application to provide information on why that person lacks sufficient credit or rental history. If the tenant does not submit the addendum within 5 days, the application may be denied on insufficient rental or credit history. The second screening provision in the bill is a written admissions policy. Landlords must establish a written admissions policy describing the criteria they will consider. The criteria cannot conflict with federal, state, or local laws, and the policy must be made available with the lease application and posted on the landlord's website if she or he has one. A landlord who denies a lease application of a prospective tenant must provide the tenant with a written or an electronic document stating the specific reason or reasons for the denial. Washington State does this. It requires that landlords give a plain English explanation for why an applicant has been denied. Most landlords simply create check boxes that would say, for example, denied for credit or denied for criminal history. A landlord cannot deny a lease application based on a reason not included in this rental admissions policy. Under the lease renewal section of this bill, it's very straightforward. It's identical to the screening language in the bill in that a landlord cannot fail to renew a lease based on a tenant being the victim of a crime or the victim of domestic violence as defined under Maryland's family law article. There's a damages section in this bill for tenants, 2 sections that have been made consistent, whether a tenant is denied a lease renewal in violation of this bill or declined for renting, and the damages are not less than 3 months' rent, court costs, and reasonable attorney's fees. There were a number of amendments, mostly striking original provisions in the bill. So committee members should be able to find a copy of a reprinted version showing all of those deletions. I did drop some income ratio language and a damages section related to when a tenant makes an unsubstantiated claim. That language never should have been in the bill. Mr. Chairman and colleagues, I am going to wrap up by saying that these screening and lease renewal reforms were needed prior to the pandemic. With the housing hardships associated with COVID, they are more necessary and more timely than ever. I thank you for your consideration, and I respectfully urge a favorable report.
Okay, thank you very much, Delegate. We're gonna go through the proponents and then we'll entertain questions. And they would be Maryland Legal Aid, so I assume that's why Greg Count is here. Zuffer Shah, Matt Lozak, Carissa Hatfield. That's it. It's those folks. So why don't we start with Greg Countess? Welcome back to the committee. You got 2 minutes.
Mr. Chair, I'm sorry to black myself out on this. Let me on my camera. I'm actually not the Maryland Legal Aid though I appear here a lot for Maryland Legal Aid. I'm not the person that is supposed to be speaking today.
Well, then let's go to Zuffer Shah. And do you happen to know who the person is who's going to speak for Legal Aid?
Yes, I'll try to get into the chat so I can give that to
okay.
the person.
All right. Well, let's go to Zuffer, then Matt Lozak, then Carissa, and hopefully that person will pop up by then. Zuffer.
Thank you, Chairman Barve and Vice Chair Stein and members of the committee. I'm Zuffer Shah from the Public Justice Center. We've signed on to the Renters United Maryland written testimony submitted for this bill. We thank Delegate Lehman for bringing House Bill 1223 to prohibit the use of certain categories of information in lease application denial and requiring transparency about application denial. I want to bring some context to this. As we know, the rental marketplace is changing. Nearly every aspect of leasing has an app. There's a tenant screening industry now valued at $1 billion, leveraging algorithms and integration with property management software. According to the New York Times in May 2020, tenant screening companies produce cheap and fast, but not necessarily accurate reports for an estimated 9 out of 10 landlords across the country. And the potential inaccuracy of these reports is a major problem for renters whose prospective landlords are relying on those reports. And this is best illustrated just over a month ago when the FTC levied a $4.2 million fine on the prominent property management software company Appfolio, which was selling reports that contained outdated and incorrect information about applicants' eviction and criminal records, including records that were more than 7 years old. And the director of the FTC Consumer Protection Bureau said this. He said, consumers face enough hurdles in obtaining housing without the additional burden of inaccurate background checks. Now, not every tenant in Maryland can rely on FTC enforcement. So what do they do when their landlords have bad information in these reports? House Bill 1223 is a very measured, modest approach is a first step to giving tenants the tools to deal with this problem. Just as Delegate Lehman described it, we emphasize that there is an effective remedy through civil penalty or a private right of action in this bill. We urge support from this committee, a favorable report. Thank you.
Okay, Matthew Lozak. Matt, you in the house?
I am, and
Okay.
thank goodness I remembered to sign on. Good afternoon, Chairman Barbie. Thank you, Delegate Lehman, for this legislation. I'll be very brief. I just want to make sure you understand that the Renters Alliance is very much in support of this bill. We mirror what the Public Justice Center's expert, Zephyr Shaw, has said. We think it's extremely important that renters have accurate background information. Also in context of another bill about mobile screening reports that Delegate Polakovich-Carr also mentioned. This is part of a package of making sure that renters who apply to rental housing, especially multiple rental housing, have accurate background checks, have the ability to fix those background checks, and that not become overly expensive for them. And so we ask you to support this bill.
Okay, thanks, Matt. Next, Carissa Hatfield with HPRP, the acronym of which I have forgotten. Is that a law firm?
Can you hear me?
Yes, I can hear you.
Okay, great.
And see you.
It stands for the Homeless Persons Representation Project.
Right, that's it. Okay.
Thank you, Mr. Chair, members of the committee. Thank you for the opportunity to be here today and testify in support of House Bill 1223. We thank Delegate Lehman for her work on this bill and for continuing to be a partner in supporting housing for renters. House Bill 1223 is a multi-part bill. I won't belabor too many of the points that have already been gone over by Mr. Shaw, Mr. Losak. I do want to speak to two of the parts of this bill that are very important, both to the Homeless Persons Representation Project and to Renters United Maryland, of which HPRP is a member. The first is speaking to the written rental admissions policy that is required by this bill. This creates transparency and accountability. Landlords would be required to provide to tenants a copy of their admissions policy, which means that tenants wouldn't be applying for units where they weren't a good fit. For example, I know many of my tenants have applied for multiple units and not realizing they may be applying for a singles unit when they have a family, or they may be applying somewhere that's not going to be appropriate, that's seniors when they're under senior age, and doesn't allow them to waste their precious financial resources. The rental admissions policy also creates accountability and an understanding of what will happen and how a tenant will be admitted. If the tenant is not admitted for a reason that's not in the written rental admissions policy, then the tenant has a right to a civil action. This is already done on the federal level in subsidized housing. Properties are required to provide these policies already, so it's something that can be done and should be done. And lastly, I'd like to just briefly speak to the non-renewal discrimination, non-discrimination policies that are provided by this bill for survivors of crime and domestic violence. It's important to ensure that those survivors are not locked out of housing because of their status related to those, and also allows for civil right of action, which we believe is very important. Renters United Maryland and HPRP support House Bill 1223, and we thank you and urge a favorable report.
Okay, is the individual from Maryland Legal Aid available?
Evidently, there's been some sort of snafu, Mr. Chair.
You're going to try and wing it?
I'm going to try to wing it.
Okay,
Not wing it exactly, because I do have the points that he wanted to make.
Yeah, I got 120 seconds.
All right. So I guess I would start out. My name is Gregory Countess. I'm with Maryland Legal Aid. I'm an attorney there. Handles landlord-tenant matters as well as other matters. As you guys know, the Maryland Legal Aid represents tenants throughout, as well as other clients throughout the state of Maryland. I'd like to start out by endorsing the comments made by the speakers before me, and also thanking Delegate Lehman for introducing this bill. And the reason why it's apropos is this. Just to give you an example of a lady, I'm going to call her Miss S. Miss S was 72 years old. She had worked for the city of Baltimore for over 26 years. She got into a minor dispute with her landlord that resulted in the landlord issuing a breach of lease. The landlord took action, or their attorney, advising the court that she had, in fact, consented to judgment. She had not, and we got that reversed. In the meantime, the landlord was not, of course, happy about that and wanted to pursue eviction. Ms. S tried to find a place to live. She applied to several different places. She's 72 years old. She was denied. She was never really given a reason for her denial. This bill would help to at least provide her with transparency so that she would know the reasons for that. Eventually, Ms. S became homeless. It's a 72-year-old woman living in her car as a result of a tenant holding over action that was filed, and the fact that she moved or had to move out of the premises. This bill will go a long way toward addressing the issues of folks like Ms. S, and we would urge a favorable report.
Okay. Any questions for the sponsor or the proponents of the bill? Delegate Holmes.
Thank you, Mr. Chair. All I want, quite frankly, is Mr. Shaw referenced Appfolio, and I would really like to see that report that Mr. Shaw referenced from Appfolio, because that is one of the larger property management software company. I want to see what's contained in that report, Mr. Shaw, if you don't mind.
I'll send, I can send that to you personally, or I can send it to the committee as you prefer, Delegate Holmes.
You know, we're all getting inundated by stuff. Why don't you just send it to Delegate Holmes and I'll allow him to be the gatekeeper. I know that sounds nefarious.
Thank you very much.
I have a question. It was said by somebody that landlords shouldn't get a hold of information that's been sealed by the court. How would a landlord get information that's been sealed by the court?
Mr. Chairman, that was me who said that. That is one of the three major provisions under the bill's screening section, and it's specific to information related to a court record that was sealed by the court. I'm not an attorney. Perhaps Mr. Shaw or someone else could shed light on that. I do know that there are a lot of databases that landlords and others can trove for information that a few years ago would have been very difficult to obtain. But I'm not sure if he has more specific insights as to how people can get to that kind of information.
Yeah, I'm very curious.
No, thank you, Chairman Barbe and Delegate Lehman. That's really the heart of it. That's data extraction types of companies are able to either electronically, use whatever's available online to crawl for information about any variety of cases. But even in terms of at court work here, these companies can go to the district court, make photocopies of eviction cases, for instance, as soon as they're filed and there's not been a disposition. So there's not been any sealing. Of course, eviction cases are not sealed typically, and there's pending legislation before the legislature to seal these records. But if it's on case search or there's a physical copy at the court, and that is a document that might be monetized by these data-driven companies, then we can expect that they'll reach those documents and produce a new record that the court has no control over, and that's what HB 1223 is getting after.
Okay, Delegate Ruth has a question.
Thank you, Mr. Chair. This is just a follow-up to what Zephyr just said, and I don't know if you can answer it or if somebody else can, but I just wondered, do you know if there are companies that have apps that just suck the data down from case search and store it all, so that, as you said, if while it's open, they've gotten it, and then if it becomes sealed, they actually still have the data?
Thank you for the question, Delegate Ruth. I actually I haven't used the apps, but there's these software suites, and there's more than Appfolio. They certainly can produce information about delinquency. I'm not clear on court record information, such as a case number that would be stored in these apps, and maybe if there are industry folks who are going to be opposing the bill, they can answer to that.
I think the term I was thinking of is scraping case search.
Delegate Ruth, if I could just, my experience in the Silver Spring and Rockville courthouses back in the day, which is now 5 years ago or so, when CoreLogic would come and physically photocopy filings of eviction filings. So one can only extrapolate that now as the internet gets even more sophisticated, so does that operation, as one example.
Thank you.
And I can speak to experience as far as tenants who are in subsidized housing or attempting to apply for it. The housing authorities use software to pull information directly from case search. And a lot of times that information may be outdated or incorrect. Conviction dates may be wrong, and those things can lead to erroneous denials. So at the very least, subsidized housing authorities are using case search as a means to try to either accept or deny tenants.
Thank you.
Any further questions for the sponsor or the witnesses? Seeing none, thank you very much. Let's proceed to the opponents to the bill. Catherine Howard, Chris DiPietro, Eric Ellman, Lisa May, Aaron Greenfield, and Aaron Bradley. So we'll start with Catherine Howard with Chris DiPietro on deck.
Good afternoon, Mr. Chair. Can you hear me?
I can hear you and see you.
There you go. That's great. Thank you very much for allowing me to testify today. I think the main testimony is going to be provided by Aaron Greenfield for the Maryland Multi-Housing Association, but I am Catherine Howard, General Counsel of Regional Management, Inc. We own market rate, very low and middle income housing in Baltimore City and Baltimore County, and we are a member of the Maryland Multi-Housing Association. We have several issues with this bill. I think that we can offer amendments on that along with what MMHA has done. We are particularly concerned about two parts of the bill. One of them has to do with the renewal section of the bill on page 6, line 29. We would offer that there should be inserted the word solely between a landlord may not elect to renew a lease solely based on information reasonably related to his tenant's status as a victim of domestic violence. We believe that victim of a crime is far too broad and not defined, but we understand victim of domestic violence, and it should be that way, but it should be the sole reason, not the simple reason. because there may be other things that are going on in a home with domestic violence. And I'm sorry, there's an ambulance going by my office. Anyway, and the other thing is that we are concerned that we often find people who come back to us over and over again who were not wonderful tenants to begin with. And we would like to be able, we intend to be able to essentially look at that background with our own records. And there's no provision in here that would allow for that. I'd be happy to write an amendment that would encompass that concern.
Okay, next, Chris DePietro. Chris, you out there?
Thank you. Mr. Chairman, members of the committee, my name is Chris DePietro. I'm here on behalf of the Consumer Data Industry Association. CDIA is the trade group that represents the consumer reporting agencies along with tenant screening companies. I have Eric Elman. I'll be very brief. We do have some concerns with the bill. I'll be very brief in my testimony. Eric Elman from CDIA is here. Hopefully he can go right after me and go into more detail as to express our specific concerns with the legislation.
Yep, well, he signed up right after you. So Eric, welcome back to the committee.
Thank you very much, Mr. Chair, members of the committee. Eric Elman with the Consumer Data Industry Association, CDIA. We are a trade association of consumer reporting agencies, which include the nation's leading residential screening companies. Our objections to this bill relate to the screening components of the bill and not to the non-screening components. And our principal objections are several. One, this bill is already covered by existing federal and state law. This bill in part is preempted by federal law, and it's already covered by provisions in a second bill by Delegate Carr, which is expected to pass as with amendments. We were favorable with amendments on that bill. I expect that bill to pass subcommittee tomorrow. So I think there's a lot of parts of this bill that have already been taken care of by federal and state law and by pending legislation that seems to be on its way, which we're certainly fine with. A couple of quick specific points. On page 3, lines 16 through 21, that's all covered by another bill that we were able to reach amicable agreement with Delegate Carr. The 7-year component is not exactly correct. Under federal law, convictions can be reported in perpetuity, while other adverse information, including arrests or credit information, cannot be reported by law after 7 years. So that particular provision is unnecessary and also preempted. And anything that deals with notices that landlords have to give consumers about decisions based on a consumer report, that would also be covered by existing law and also preempted. As a matter of course, we have a high degree of accuracy standards we're required to adhere to by law, and we don't report sealed cases. I'm happy to take any questions that you or the committee have.
Okay, next is Lisa May with Aaron Greenfield on deck.
Thank you, Mr. Chairman, members of the committee. Lisa May with the Maryland Realtors. I believe our other panelists here will cover some of our comments, so I do want to be brief. We certainly understand the desire to avoid having tenants pay unnecessary fees. In this case, we think a 60-day time frame is too long. A lot can change in terms of credit scoring, employment, and things of that nature during 60 days that would allow a landlord to fully evaluate a tenant and also make sure that that tenant will be successful in the lease. So we think 30 days would probably be a more appropriate time frame for our landlords. Also, just general concerns that the other clauses within this bill introduce some subjectivity into a landlord's evaluation process. And I'm sure the proponents would say that, yes, that's exactly what we are trying to do. But from the landlord's standpoint, that subjectivity can open them up to additional liability, to claims that they are not treating tenants fairly under fair housing or other standards. And we just really want to caution you against that, because when landlords view that risk as being too high, especially those who rent single family homes, condos, or townhomes, they may view that that's a risk that they don't want to take, and they exit the marketplace, giving everyone fewer rental housing options. So with that, I will close my testimony and ask for an unfavorable report. Thank you.
Okay, thank you. Next, Aaron Greenfield, followed by Aaron Bradley, and then we'll go to questions.
Good afternoon, Mr. Chairman, members of the committee. Aaron Greenfield here on behalf of MMHA. You have our written testimony, and I'm here in opposition to House Bill 1223. I have not seen the amendments mentioned by Delegate Lehman, but do look forward to seeing them. We have several concerns with this bill. Let me first start with the application fee piece on page 3, lines 16 to 21. 8213 of the Real Property Code already caps application fees at $25. Furthermore, this bill fails to define landlord or owned and managed by a landlord, which creates the likelihood that one applicant could apply to multiple properties owned or managed by one property management company well within 60 days. There's clearly a cost associated with processing these applications, and the tenant ought to be responsible for that expense. On page 4, lines 17 through 30 deals with an addendum and denials. We believe this addendum process actually creates fair housing discrimination potential if exceptions are made for financial qualification, which is very important. We're not allowed to make exceptions to financial qualifications, and this addendum process could lead to that. Page 5, lines 2 through 13 deal with the income ratio. Housing experts estimate that a person should not pay more than 30 to 35% of their income for housing. Under this bill, housing could absorb 100% or even 50% of a resident's income. This could reasonably result in eviction. And if you want to protect a prospective applicant, this is not the answer. This is, in my mind, akin to predatory lending and placing the tenant, quite frankly, in an untenable position, certainly causing enough tenants an eviction tsunami. For those reasons, we respectfully request an unfavorable report.
Okay, and the final unfavorable witness is Aaron Bradley with AOBA.
Good afternoon, Chairman and committee members. Aaron Bradley with the Apartment Office Building Association of Metropolitan Washington. We have several concerns with this bill as laid out in our written testimony and covered by MMHA. I'll also say Lisa May with the realtors hit the nail on the head about subjectivity. Much of our opposition with this bill centers on how it currently works against the screening process put in place by housing providers to abide by fair housing laws. So I just want to discuss how AOBA members currently screen applicants. To ensure that applicants are not subject to unintended bias and are each treated consistently under the law, AOBA members submit application materials to a third-party screening company. Rather than receive a detailed report about an applicant's circumstances, they receive a verdict, either approved, conditionally approved, denied, based on the property management company's established, comprehensive, and predetermined rental requirements. These requirements are not limited to rental history and credit report, and credit report does not in itself deny an applicant. For background checks, most members only check the sex offender registry and certain violent crimes. When AOBA members receive a denied verdict from the screening agency, in accordance with existing federal and state law, companies provide notice to the applicant indicating the application was not accepted based on information obtained from a consumer reporting agency. The management company then provides the applicant information for the reporting agency so that applicant can provide information directly to the reporting agency. The housing providers AOBA represents do not want to request an addendum or explanation of credit or housing history, as it would give on-site management staff individualized information about the applicant that may open the applicant up to unintentional bias, whether it be positive or negative. It sounds like the income requirement section has been amended out of the bill, so that concern about requiring housing providers to disregard their universally applied acceptance criteria has been addressed. But for these reasons, we respectfully request an unfavorable report. Thank you.
Okay, questions? I was muted. Delegate Harrison.
Thank you. I think, Ms. Bradley, I have just a clarification question for you. So you said that that your members, and I realize that not all apartments are members of your organization, apartment owners, but they don't, I go to apply for an apartment, you go to a third party organization to do a check. And you said that that the denial or acceptance is not solely based on credit history. Is that what you said correctly?
Yes, Delegate Harrison.
So there could be, so my credit is, I'm at a, 500. I'll even say a 400. But I've been gainfully employed for, 2 years, and I'm looking for an apartment. And so my credit is at a 400, but I'm gainfully employed. And that's the issue. So you're saying that I would not be denied?
No, I'm saying you would not solely be denied on your credit history. So there are, of course, financial requirements that are put into all of the criteria for application that go off to this third party company. And so your credit, and I don't know, every company has its own threshold, every housing provider has its own threshold, but your credit at 400 may get you conditionally, your credit at 400, but your job history and your exemplary, rental housing history might get you conditionally approved. I can't speak with certainty on that. I'm just saying that having your 400 credit score will not always in itself deny you housing. Again, some housing providers, smaller housing providers might have a lower threshold. I can't speak to that, but there are criteria that are comprehensive and not based on one thing.
And just to follow up, so let's say I don't have a rental history and 500 credit score, but gainfully employed. I'm just trying to, I guess what I'm trying to get to is I apply to, I'm denied here for whatever reason. And every time I apply, I have to make an application fee, and I'm constantly being denied. So I'm out $25, and I could do that, once a week for 60 days. So I'm out all of that money, and I still don't have a place to live. And that I may have is a low credit score and no rental history. I guess I just want to make sure that, individuals actually have a real opportunity when they don't have a felony or anything like that, but I want to make sure that they have a real opportunity. And I think that it sounds like that's what Delegate Lehman may be trying to get at. One of the things she's maybe trying to get at in this bill. And I just want to make sure that, that we are, in fact, being as fair as we can and offering opportunities as we can.
Absolutely. Delegate Harrison, if I may, I will say that when you get a denied, they do tell you it's based on a report and suggest that you contact the reporting agency to see with regard to the denial piece in the bill, if that's certainly something that we could look at, and we'd be happy to work with the sponsor to work on. It's just other pieces and other provisions of the bill are problematic for fair housing and a number of other reasons as addressed by this panel. But the reporting of the denial and the reason why, we can certainly work with the delegate on.
Thank you. I'll listen.
Thank you.
Okay, next question goes to Delegate Terraza, then Delegate Lehman, the sponsor.
Thank you, Mr. Chairman. I think this question is for CDI. I guess there were 2 people. Mr. Ellman said something about there are accuracy standards. Can you tell me where those are found and what the enforcement is on those?
Sure. Thank you for the question. Under both federal and state law, consumer reporting agencies are required to maintain reasonable procedures to assure maximum possible accuracy. And our members compete every day on the accuracy of our files and the accuracy of the reports. In fact, when tested in a variety of federal appellate courts, our accuracy rates have been found by several federal appellate courts to be 99% or better. Any alleged violations of the Fair Credit Reporting Act or federal or state can be sued by private right of action. There is no cap on class action damages for private rights of action. Any state attorney general can enforce federal law in in federal court, or state law in state court. The Federal Trade Commission and the CFPB also have the power to enforce those. Going back to a question that was asked by Delegate Harrison on the notices, that under federal and state law, whenever a landlord or any other person, whether that be a car dealer or whoever, makes an adverse decision based in whole or in part on a consumer report, which in this context would include a tenant screening report, is required to give to the consumer a notice saying you are being denied in whole or in part based upon information provided to us by company X, the screening company, and a consumer then has yet another right to get yet another copy of that report.
Okay, so I wasn't quite done there because you said you're required, so the standard is that you're required to have reasonable procedures. Is there anything more than that?
Reasonable procedures to assure maximum possible accuracy.
Right, but there's not a standard by which that, like,
Well,
I don't understand what kind of standard is that?
Yeah, and that's a good question. That standard has been in place in federal and state law for half a century, and it is tested every day, both in the marketplace and in the courts. And there is a
wait. So is there another piece of that standard? I mean, is there anything else more specific, like a percent accuracy, or is there auditing of that, or?
There's significant regular auditing. Many of our members are supervised and examined by the CFPB. Many of our, and we, like I said, we are tested in the marketplace every day. There is enforcement.
Tell us what the CFPB is, please.
Oh, sure, of course, the Consumer Financial Protection Bureau.
Okay, thank you. Go ahead.
Sure. So again, when these accuracy rates have been tested, and they are tested regularly, like I said before, we've seen accuracy rates north of 99%.
Okay, so, but you said that you're tested in the consumer market, but the consumer is the landlord.
No, well, yes and no. I mean, the customer is the landlord, the consumer is the consumer.
Right,
and
they're not choosing what company is used. So they don't go to the company that's most accurate.
Well, the Federal Trade Commission has said that our members compete on accuracy, and the Federal Reserve has said that consumer reporting agencies compete on accuracy of the data.
Okay, well, if you can provide any information in writing to us about what that is, I would appreciate that. And then you said that with regard to the reports, so a tenant can ask for that as long as they're denied, they are allowed a copy of the report. Is that what you said?
They can get a copy of the report at any time.
Whether or not they're denied?
Correct. When they are denied, they get it for free. Some charge up to, I think federal law caps it at, I don't know, $10.50 for the reports. If you get a report from a nationwide credit bureau, you're entitled to it by law once per year for free. But the credit bureau has announced earlier this morning that they are extending for yet another year, one free report per consumer per week.
Okay.
So that's up to 52 free reports in a year.
And they can do, what do they do if it's incorrect?
The federal and state law have a fairly elaborate, extensive dispute resolution procedures. These disputes have to be resolved within 30 to 45 days, depending upon the circumstances. Most disputes are resolved in far less time than that.
You have to resolve it with them.
Well, sure. If I get hit by a car, I have to talk to the insurance company. If there's an error that I don't feel is right on my report, I have to dispute that.
Thank you.
Okay, next question goes to Delegate Lehman.
Thank you, Mr. Chairman. And I have been communicating with Delegate Polakovich-Carr, and she said it was okay to let the committee know that I have worked with her on this bill. And she did part of the research on it, and I did part of the research, and I am happy to do a brief side by side, either for the Housing and Real Property Subcommittee or the whole committee, on how these bills are different. Excuse me, I'm sorry. I would really encourage the opponents. I realize that several of them said they had not seen the amendments, to please look over the amendments. I forget who it was, but the second opponent who spoke, almost everything he talked about has been struck from the bill. The $25 fee language is gone. All of the income ratio language is gone, not because we thought it was discriminatory, as whomever it was suggested, but we just thought it was getting a little bit more far afield from the bill, and it would be sort of harder for folks to get their mind around. We were trying to keep the bill tighter. Mr. Ellman, if there are any preemption issues, I would welcome an opportunity to speak with you. I certainly would not have intentionally included any preemption issues in this bill if I thought that was a problem. I would not have wasted this committee's time. And then I guess I wanted to ask a question of Ms. Bradley, who talked about, in response to Delegate Harrison's questions about potentially being denied, saying, we send basically folks who have been denied back to these reporting agencies. Are you saying then that you would object to the Washington state approach that a landlord should have the responsibility of providing a plain English language explanation of why somebody was denied? Is that too big a hardship in your mind? And what if your reporting agencies weren't accurate?
No, Delegate Lehman, I said that the reporting part was fine. It's just going back and forth about the facts of the denial were problematic. We prefer for them to deal with the Consumer Reporting Agency, but giving a plain text reason, I believe I said to Delegate Harrison that we'd certainly be happy to speak with you about that specific part of her question.
Well, and I thank you for that. I thank you for the opportunity sincerely, because I think it would reduce that back and forth that you're concerned about, that I could see you getting into, and then it puts the landlord in an awkward position. And look, I recognize there are more good landlords than bad, and I think it's fair to say a lot of you, probably most of you, depend on your reputation. You want repeat customers in a good way, and you want their friends and family coming to rent from you. So, I am willing to work with the opponents on this call, but I am most concerned probably about the characterization that this is, broadly overlaps with Delegate Polakovich's Carr's bill. She has an excellent bill, mostly focused on making tenant screening cheaper and more accurate. And whereas mine is, sort of more accurate and fair and transparent, the goals are similar. But I really don't think it's fair for somebody that's, and I say this respectfully, Mr. Chairman, that's in opposition to say, oh, there's this other bill that's, better, and it's about to pass out of subcommittee. I don't think anybody here has a crystal ball, and I don't think that's a reason to oppose a bill. And thank you.
I agree that nobody has a crystal ball, including the chairman, but it's perfectly, well, I have a better crystal ball than most people, but it's perfectly acceptable for a witness to say we prefer this bill to that bill. That's done all the time. So anyway, Delegate Healy has a question.
Yes, I do. Thank you. Mr. Ellman, I was interested, and also, I guess, I can't remember who it was that talked about the process. So it's based on what the landlord seeks to, what's in the contract, whatever criteria that the agency follows in doing the research, and what they're looking for, the checklist of things that they're looking for may vary from landlord to landlord. Is that correct? Mr.
It is, Delegate Healy, not unlike a college or university has different criteria for what scores they will accept from a high school, or for those universities or colleges that are taking an SAT. One set of grades might mean something to one school, which might be something entirely different to another.
I guess the testimony was that these agencies don't necessarily just provide the landlord with information, all this data about the person, but they render a judgment that what you found for this person, that you should rent to them or not.
Delegate Healy, the answer to that is no. We present accurate information that a landlord then makes an up or down, yes or no decision on.
So you have just objectively collect information and share the information that's been requested.
Correct. We don't make recommendations. We don't make decisions.
Okay. Now, somebody in the testimony earlier, maybe it was Aaron Bradley, about the process that the landlord, what they're seeking from these agencies, and that they want a yes or a no, or an up or a down, or some kind of qualified recommendation, whether they should accept this person as a tenant or not.
Sure. And so
criteria they give them.
Sure. So based off the criteria, different companies do it different ways. And I think one of the, like someone else said, do not use the services myself, but I've been told some people get numbers. Some people get conditionally approved, denied. So it comes in various ways, but based off the criteria, yes, the companies that many of my members use give more than just objective data. Some may rely on just objective data, but many indicated that they like the other way. So there are no unintended biases that come into the process, and they treat all residents the same without anyone on site knowing the particulars of an individual's life.
Okay, well, I understand that. My question about that is, and I wanted to ask one of the agencies that do this kind of research, when they evaluate that and they opt for a person and they're turned down by one landlord, and then the next landlord sends the same agency a request, but maybe they have slightly different criteria. And so but would they get the same recommendation just because, we've already seen this person and we already know that we don't think they're a very good risk. And so based on the fact that we've turned them down before, even though the next landlord maybe doesn't have the same standards. And are you aware, is there that kind of thing happening?
Sure. I can't speak to the companies, as I said, and as you know, I can't, but I can say that the criteria that the property management company and the owner set forth is supposed to be the criteria that stands. So.
Okay. Is anybody, okay, maybe you're not the right person to ask. Mr. Ellman, does anybody monitor or hold these credit agency companies, these credit research companies to really follow what they're requested from each specific landlord, rather than doing, we did that research on this person and we know all about them, so we can just say they're a good risk or not a good risk?
Yeah, well,
your company doesn't do that, so I don't know if you know about a company that does. I'm just trying to figure out how this.
Sure. Yeah, let me try to take a run at that, and hopefully I can explain it better. And if I'm not, then feel free to try again.
Well, I'm not going to try again. I'll just take it offline after that.
Fair enough. Our members provide information to a landlord, and that information is produced under both the Federal Fair Credit Reporting Act and the Maryland Fair Credit Reporting Act. Again, adhering to these accuracy standards that's been set. We provide the information to the landlord. It is the landlord that makes the decision, yes or no, up or down. We do not make recommendations. We do not make decisions. That's the landlord's job. We write the books. It's up to the reader of the books to interpret what they get out of that book. So
okay, so but that's just one company. That's not the whole industry, right?
No, it's all consumer reporting agencies. Consumer reporting agencies produce information under federal and state law, provide that information to landlords, and the landlords make those decisions. I'm not aware of any consumer reporting agency that makes the decision.
Okay, thank you very much. Appreciate it.
Sure.
Okay, I've got a question, because I've never been in this business space. I've never been a landlord, but let's say, for the sake of argument, that I'm a landlord and I wish to have as a standard that I don't want to rent anybody for whom the rent is more than 25% of their income. Can I do that legally? I'm just curious, is that a legal thing for me to say that?
Well, Mr. Chairman, I don't know the answer to that question. That
No,
is
I
probably
wasn't, well, I wasn't directing it to you. I was directing it to maybe Aaron or Aaron or somebody like that.
But if I could, though, the screening companies don't carry income information, so that would be the information for the landlord.
Oh, well, I still want to know the answer. Aaron, do you have Mr. Greenfield, do you have an answer?
I was going to defer to Kathy Howard.
Okay, Kathy.
I was going to put up my hand, but I thought I'll just wait for somebody to call on me. Yes, I think it is. That is a legal criteria. The landlord knows his rental portfolio and what the prices for his rental units are, and essentially sets an income to rental price ratio that is going to ultimately result in the success of the tenancy. At least from they use their experience, they use market-driven forces. All of those kinds of things go into that assessment of what can be the criteria. And it's interesting. Oftentimes, if there is someone, say, on the edge of maybe not meeting that criteria, or being right on the edge, that it is going to be up to the landlord to decide whether or not to take that risk of renting to that person who is on the, I'll call it on the bubble, if you will. And one of the tools that's available to assist in that is the fact that you have a security deposit. Under Maryland law, you can have it can be the equivalent of 1 month's rent or 2 months' rent. I know that in our shop here in Baltimore, if there is someone who is sort of on that edge of whether or not they actually hit the income requirement, and they are willing to get either a cosigner. For instance, let's talk an example. Students are a very good example of this. A student who's coming in to go to college does not have income in their own, generally speaking, income in their own right, or very low income in their own right. But we will still rent to them because either their parents will co-sign for them, or we will get a double security deposit that they may be able to pay over time, over the course of the lease. And yes, then they are going to be a renter. People with bad credit are also a potential, if they have income that meets the criteria, but they have bad credit, then that's a consideration that we will take into account, and potentially use that as a reason to ask them to get a cosigner, or a little bit more of a guarantee, or give us additional security deposits. But that depends on each and every landlord and what their market looks like, as well as their rental housing stock. But
Okay.
but it's not illegal
Okay.
to do that.
Well, you've given me
Those are business decisions.
You've given me a picture that I wanted to see. There are no further questions, so I believe that ends the public hearing on House Bill 1223. Thank you, Delegate Lehman. Is Marlon Ampry in the House? Marlon?
I am here.
Okay, you're next then, and then you're free to go. So we're going to jump to House Bill 1325. Go for it.
Thank you so much, Mr. Chairman. Members of the Environment and Transportation Committee, is a pleasure.
You had to think about that, didn't you?
I got 3 bills today. I got so much on my plate. But thank you all so much. It's a pleasure to finally introduce a bill to my own committee. Today I'll be introducing House Bill 1325. It's being introduced for the purpose of requiring the Department of Housing and Community Development and the Department of Planning to produce a report for each state legislative district on the food environment in the district. The reports will include detailed metrics that identify health food priority areas, formerly known as food deserts, and will calculate the Healthy Food Availability Index in each district. This bill is really near and dear to my heart, considering that in my own district, we have a severe issue with access to fresh food. And our community activists are working hard to get the access there. But there are a lot of ways in which we can do more work at the state level to encourage things here in Baltimore City. And I think that based on my study and looking at some of the pushes for more equitable food distribution throughout the state, one of the issues that I'm noticing is that everyone has these awesome solutions. We really don't have a baseline of where the issues are across the state. Like what really constitutes a desert or a district that really requires more access to better food. I had the opportunity to sit in on some of the economic matters recent hearings, and there were several really thoughtful legislative bills that came forward that were dealing with food insecurity. But many of the issues that were come by the way of opposition was the fact that there wasn't really a true baseline of where the state could really say what areas are really in need of severe help when it comes to food. And just to give you some quick statistics over some of the issues that we face in the state, approximately 1 in 4 Marylanders face food insecurity or the state of being without reliable food access to nutritious food, according to the Maryland Food Bank. This has devastating impacts on children, as data shows that children who do not have access to breakfast score 17.5% less on standardized math test scores, the difference between an A and a C, and often sometimes the difference between moving on to the next grade. And seniors are also disproportionately impacted. Food insecure seniors are 65% more likely to have a heart attack. And we know that many of the health issues have been exacerbated by our recent pandemic. As an example of the detail provided in these, so one thing that really inspired this piece of legislation was recent reports that we actually have been provided by the Johns Hopkins Johns Hopkins provided Baltimore City with detailed maps for each legislative district and within our council districts that details exactly these metrics that I would like to see put forward across the state. And I'll quickly share my screen if I can. Let's see here. Or I think, Trish, do I have to do it, or I'm not sure how this necessarily works.
Usually we just need advance notice so we can, but I think Uriel took down the timer, so you can do it if it's okay with the chairman.
Yep, it's fine with me.
Okay, thank you so much. I can't get. Oh, there we go. Share screen. All right.
Well, maybe.
Okay. What I can do? Well,
you can email it to us.
Try now. Try now.
Okay. Okay, there we go. Are you able to see my screen?
Yeah, let me just make it bigger. It's your Outlook
emails.
Looking at my email right now. That's weird. You don't see like my screen?
I see your screen and you're in Outlook, right?
No, I have a map up right now. You don't see the map?
I don't see the map.
You probably should close your tabs.
I do this all the time. All right, let me stop the share. I'm so sorry. Let me try again. Because the maps are really what make this more clear. All right, here we go. So if you look here, are you able to see the screen now?
I can see the screen, yeah.
Okay. I'm so sorry. But this is what really inspired me to introduce legislation. We don't have this level of detail over food environments across our state provided in each legislative district. So if you look closely, this is just for the 40th district, and we have one for each district in the city of Baltimore. And it breaks down like literally every detail in regards to food access for residents based on income, based on race. And if you look here closely, there's an actual map of the glorious 40th district. And what you can see is it's not so glorious when it comes to food access.
So wait a minute, what do the colors mean? Is green good and red is bad? No, it's the opposite.
Yes. No. So you're right. So the red are healthy food priority areas.
Okay.
So these are areas where we've identified where there are issues with food access. So
Okay.
these are areas, and all the metrics used in order to create these areas is based on certain factors in regards to the residents' access to where they're able to drive or whether it's public transportation.
So Marlon, would your bill require this of all the districts in the state of Maryland?
Yeah, so this bill will require maps of this detail or the detail necessary based on what the localities that will work with the state to determine what are some of the needs there, because we know Baltimore is probably our most densely populated area within the state. So some of our more rural districts might need different metrics and different tools in order to assess what is really the food accessibility issues that are there.
Okay,
Yeah,
well,
so the goal of this bill is just to create this map so we can have a baseline structure and ensure that as we build out policy to create more food access, we have a way of seeing the problems before we create more solutions. And I hope for a favorable report, and I look forward to your questions. I don't want to take up any more time.
Okay, well, all right, let's go to Holly Friestadt and Shelby Calm, and then we'll go to questions. Holly.
Great. Good afternoon, and thank you, Chair, Vice Chair, and members of the committee. I'm Holly Friestadt, Baltimore City Food Policy Director and the Division Chief for the Food Policy and Planning Division and Department of Planning. I'm here today to support House Bill 1325. The Food Policy and Planning Division, we oversee the food environment mapping, and we produce those maps that you just all saw from the delegate. That includes the healthy food priority area layer, which I will discuss in 1 minute, and then it overlays the food environment, which is the most important part. So that's overlaying the supermarkets, the corner stores, the convenience stores, the farmers markets, the urban agriculture, and nutrition assistance. So we have a definition for healthy food priority areas. The most unique piece that's only unique to Baltimore is that we have a healthy food availability score, where we surveyed in collaboration with Johns Hopkins Center for Livable Future, 800 stores to get a score. It's also low income, 185% of poverty, 30% of people do not own cars, and a quarter mile from a supermarket. The impact is 24% of Baltimore City residents, 146,000 residents are impacted in these areas. These maps and data impacts policy and priorities. What's very important to note is that as we look at this legislation moving forward, we need to translate the methodology from Baltimore City to rural and suburban food environments. I highly recommend that you reach out to Dr. Celeste Chavez with Morgan State University, who's published a recent report on a revised methodology for healthy food priority areas. We respectfully request a favorable report for House Bill 1325.
Okay, how about we'll hear from Shelby Calm and then we'll entertain questions. Shelby.
Hello, yes, hi, I'm Shelby Calm. Good afternoon, Chair Barve and members of the Environment and Transportation Committee. On behalf of the Fair Farms campaign, I'm speaking in support of House Bill 1325. The bill would require the Department of Housing and Community Development and the Department of Planning to jointly produce a report for each state legislative district on the food environment with an eye to highlighting food insecurity zones. This includes understanding the quantity and variety of staple food groups and healthy options in various neighborhoods in the retail environment. The Fair Farms campaign of Waterkeepers Chesapeake brings together consumers, farmers, public health professionals, and conservationists to advocate for a food system that is equitable, fair to farmers, invests in homegrown healthy foods, and restores our waterways. Before the COVID-19 pandemic, food insecurity rates across the country were the lowest they had been in 20 years. Since the start of this public health crisis, there has been a major increase. The Maryland Food Bank alone saw an 89% increase in visitors from March to December 2020 over the 2019 rates. The COVID-19 crisis has also put existing disparities into sharper focus. According to Feeding America's revised food insecurity projections, 72% of counties nationally projected to have the highest 2020 food insecurity rates are majority Black. In order to craft public policies that will effectively guide equitable food policy, programs, and resources that expand food access, it's critical that we understand whether a specific locale is a healthy food environment and what factors contribute to its standing, and House Bill 1325 will help us do that. We must have reliable, up-to-date, consistent information on food insecurity. This research, analysis, and mapping that will be undertaken under this proposed measure are necessary steps in understanding the unique challenges faced by communities across the state as they seek to address food insecurity. For these reasons, we stand strongly behind this bill and urge the committee to adopt a favorable report. Thank you for your time and consideration.
Okay, does anybody have questions for the sponsor of the bill? Okay, I guess word didn't get out far enough. This is the prank that is played on every freshman delegate. Everybody has a question. Okay, who has a real question?
Actually, I have a real question.
Okay, Delegate Healy has a real question.
Yes, I do. I have a real question. I think Holly Freshott might be the person to answer it. I was looking at the fiscal note, and I wanted to ask, since you developed this for one district, how much it costs to do that? Because they seem to think it's going to cost almost $200,000 to do this on an annual basis statewide.
Yes, to be clear, our food environment mapping, and it's on our website, every single state legislative district and city council districts and city brief. It's mapping for the entire city, not just one district. All our mapping and research with the Center for Livable Future was pro bono. So going and researching every single store and getting a score for every retail store to compile the healthy food priority area layer was very time intensive, and Hopkins did all this pro bono. So I would say that it's very expensive. That cost is lower than it really is. To be clear, we don't have the funding right now to continue with this level of methodology. We're going to try to secure additional funding or look at alternative baseline layer. For example, right now, we are mapping SNAP data because SNAP data is published monthly, and I can get updated data layer. And then we're using the SNAP layer and mapping that, and then putting the overlay of the entire food environment. So that is not changing. The supermarkets, the corner stores, but we're using the SNAP data layer. And it has shown a 40,000 increase in people being impacted because of COVID. So we may want to consider other alternatives to the data layer. We say food environment mapping. We do not say healthy food priority area layer because we assume the layer could change over time. And that is why we're using SNAP now, because it's more relevant than the healthy food priority area layer from 2018.
Okay, thank you very much.
Yeah, is it possible I can add something to that, Chairman?
What? Yes, of course.
Yeah, so the bill that we've drafted has also been amended to ensure that there's actually we love what Hopkins has provided, but we understand the level of detail may be difficult to do it the same cost statewide. Also, we understand there's maybe better methodologies, as expressed earlier, that Morgan has another methodology. So the bill would not require Hopkins to do this exclusively. There's other universities that can be used, other metrics that could be used. The Hopkins map that I provided here and show was just an example of what could possibly be used as a way to ensure that what could possibly be used as a way to create a baseline what can ultimately be done statewide. The goal is to create the map, and the Hopkins map was just a kind of like a, I won't say a map for the map, but kind of like a goal or a baseline.
Thank you.
Hey, I was distracted for a bit there. Let me interrupt for 1 second, Delegate Healy. Delegate Mary, did you read the written testimony of the Department of Planning, and do you have a response to that?
I don't think I had a chance to read that.
That is me. Excuse me. I'm Holly Freshott, and that's coming from Baltimore City Department of Planning.
the
Maryland
Okay,
Department
sorry.
of Planning.
Thank you.
Okay, well, take a read that and get back to us, okay?
Yeah, we'll do. I definitely.
Okay. Anne,
I'm finished. Thank you.
You're done? Okay. Delegate Learman, then Delegate Frazier-Hidalgo.
Thanks, Delegate Mary, for bringing this. It is certainly an important topic in bill. Two quick things. One is I understand that this was how our planning department and Hopkins did it, was by legislative districts. But I just question whether it makes sense to do it by county rather than by legislative district, simply because maybe it would cost less, and certainly people can go, often go to grocery stores that are in different districts. And I just wondered if you've thought at all about, or if you have any ideas, or if you know about making it by jurisdiction.
Can I interject? Also, we're going to be changing state legislative districts.
Right.
Pretty soon, right?
They change, yeah. The other question I had was brought to my attention by one of our counsel, which of course is that we have another bill in this committee on the Maryland food system to create a Maryland Food System Resiliency Council. And I wonder if it, these are both about food systems and creating more food resilience. And I just wonder if there's some way that they can work together, or if the Maryland Food System Resiliency Council, as part of its charge, and part of the report that it creates, would be able to create some sort of report like this. So I just wondered if you had, that's a bill by Delegate Charcutine that we heard earlier this session. So just any responses or thoughts on that?
No, thank you so much, Delegate Layman. You bring up two good points, and I went back and forth about doing this by city or county or doing it by legislative district.
Yeah.
I find that with it being by legislative district, with the redistricting, that is probably the biggest concern that I had. I just found that with the legislative districts, there's more of an opportunity for there to be some system of back and forth and accountability in ways in which we can be more involved. And then also knowing that also the way our districts are drawn, understanding the demographics in ways it's done in a way in which, I think it can be more of a way where people can advocate for their issues within their actual district, right? But I do think that doing it by county is something I'm not against. I would be happy to do it by county too. I think that would make it easier in the sense that as things get redistricted, it wouldn't be as problematic. And then as far as the food council component, I think that these bills can really be somewhat of a companion piece to each other. I think the council can maybe provide some details that can then help with the decisions on how to map things. But I could see a world where I don't necessarily see where this could be inserted into that, but I do see where there's definitely a synergy that can be formed there. And I think both of these bills really work towards, trying to really think about what is at issue and what is the problem. I think everybody wants to go solve it, but we got to really see and figure out what is the actual issue first. And I think both of these bills do that well. But thank you so much for your questions. These are very, very good points.
Delegate Boyce.
Thank you, Mr. Chair, and thank you, Delegate Embry, for this bill. I remember when this data came out, I think I personally congratulated Holly on some social media platform because it was certainly useful. I just have a really silly question about, I think to Delegate Lerman's point, is it that you actually searched and gathered the information per district, or did you gather it citywide and then overlaid the boundaries?
Exactly. So
Okay.
what this legislation is really doing is that you're doing statewide food environment mapping. The data is statewide. Then you put whatever layer you want. So you can
Got
do
it.
your county layers, your city layer, legislative layer. Any of those can be produced. So that's not an issue, but the data
Got
would be
it.
statewide. And then also for Baltimore City, we actually issued these food environment briefs. The data layer was collected by Center for Livable Future, but we produced the briefs and the maps.
Right. So essentially, again, it's just a layer. So even with redistricting or anything else, we can layer it to drill it down however we want it because we'd already have the full data.
That's correct. The hardest part is what goes on top of the layer. So the layer was the red, right? The healthy food priority areas. That's one part of the layer. The second part, which is, in my opinion, the most important part, is what goes on top. All the supermarkets, all the corner stores, the urban farms, the nutrition assistants. And that means that compiling that at a state level or asking local jurisdictions to compile it to put on the map, that is where time is going to be needed as well.
Got it. Thank you so much. I wanted that clarification.
That's good to know, Holly. So basically what you're saying is that I was going to ask if doing it by county would if you thought it would reduce the fiscal note, but I mean, based on what you've said, I don't think it would. You gather all the information and then you filter it by whether it's county or state legislative or councilmanic. It's the gathering of the data is the main effort.
So the way to reduce the fiscal note is to not use the healthy food priority area data layer, which is the 4 factors. That takes quite a bit of time to survey all the stores. What you could be taking, alternatives would be, we're using the SNAP layer right now, SNAP data instead. And that's on our website. I can provide that link. where we're mapping our COVID-19 food environment briefs are all with SNAP layer. So you could change the layer to a data set that you already have at the state that gets updated annually. And then you're spending your time on the food retail environment on top, which you could buy a lot of those data sets, and that could be a way to reduce fiscal note.
You know, Delegate, you might want to look into that, because that it would, you know, we can't, you know, we have to be careful about that right now with our budget. But in any case, Peraza has a question.
Thank you, Mr. Chairman, and thank you, Delegate Mary. I think this is a great bill. I have a question about the map, which we only saw for a second, and maybe it isn't it so question maybe, but the green on the map is parks, not places where there's plenty of.
Yeah, that's what I read in the legend. Yeah.
Is that correct?
That is correct.
Making it a question, Delegate, Mr. Chairman. I for what it's worth, it's confusing, isn't it? Isn't that so? A little confusing in the visual, and I don't know if any consideration had been given to making that visual slightly different, because I think the thought of green means go, red means problem, stop. So has any consideration been given to that as you move forward? And I think this is an excellent bill, isn't that so?
I would agree.
Okay, any further questions? Apparently not. Thank you very much. That ends the public hearing on House Bill 1325. Let's go to House Bill 1226, Delegate Lasanti.
Okay. Hi there.
When you've got 4 minutes.
Wonderful. Thank you, Chairman Barve and members of the committee. Delegate Mary Lasanti for the record. House Bill 1226. The purpose of this bill is to address an autocratic provision in the state law regarding the process for petitioning local governments to consider the creation of a municipal corporation. The bill is introduced, maintains the current law. However, it adds the requirement that the county commissioners or the county council approve a referendum request if a valid petition is presented with 40% of the registered voters in the area proposed to be incorporated. As you may know, under current law, a petition may be submitted to the local governing body with 25% of the registered voters. However, the only action that the local government needs to take is that they must do a report and that they must have a public hearing once the petition is validated. Approval of the petition is, however, left to the discretion of the local governing body. In most cases, the county government opposes creating a new municipality due to the inherent conflict over the authority, land use, taxes, and services. Consequently, the will of the qualified voters in the area and the petitioners are often ignored. A system that permits a governing body to ignore a petition from its citizens is constructed contrary to representative democracy. House Bill 1226 establishes a straightforward alternative process to promote the independence of Maryland citizens to self-determine their governance. This bill is fair, just, and right. Having served in both municipal and county government before being elected to the General Assembly, I have witnessed firsthand the important role municipal government and county government play in the quality of life of their citizens. Both have an important role. However, in communities where citizens feel they are underrepresented, this alternative provides fair and equal access to local representation and improves outcomes. In the spirit of good government, I ask for a favorable report of House Bill 1226. Today, you're also going to hear from some partners in government and in the community who have had similar experiences. Certainly, former partners, my partners in government, current County Councilman Andre Johnson and former Councilman Dion Guthrie are here to tell you today about their experiences in communities with limited limited political influence, as well as a citizen activist who has worked very hard in this area over the years. So, Mr. Chairman, thank you very much, and members of the committee, for allowing me to bring this very important bill to the committee. Thank you.
Thank you, Delegate. Let's Andre Johnson, Justin Fiore, Mike O'Hearn first, and then we'll entertain questions. And there is, predictably one person signed up in opposition as well. So, but we'll go to the proponent's testimony. So, Mr. Andre Johnson, welcome to the committee. You have 2 minutes.
Thank you, Chair, and I want to thank the Vice Chair as well, and I want to thank everyone on the committee here. Thank you for allowing me to speak today. My name is Councilman Johnson. I am the district rep for District A, that's Edgewood, Joppatown, and a little bit of Abingdon. I'm going to speak briefly on this. Delegate Lasanti and I spoke about maybe 16 to 18 months ago in reference to how we could work together to increase the possibilities of, an area like Vine to incorporate. My area is not uncommon to any other area within the state of Maryland. We have our challenges in the district that I serve, and I'll just give you an example of the underrepresentation that I see from the county side versus the municipality sides. And one big issue is, it's a hot button topic issue, is the hotel tax. The hotel tax is basically, the county gets revenue from the hotels. We have a good amount of hotels in my district. However, the municipalities that have hotels in their area get 3% of that revenue off the top. Whereas in my district, where my hotels are, the revenue that is generated from the hotels within my district are redistributed throughout the entire county. So, say the Darlington Apple Festival or something of that nature, and there's absolutely positively no reinvestment within my district. So this bill would definitely be another tool in the toolbox if the citizens in my district would want to go down that road once again to incorporate. Mr. Chairman Mr. Chairman and Vice Chair, I thank you for your time, and thank you very much.
Okay, thank you. Justin Fiore with MML.
Good afternoon, Mr. Chair, Mr. Vice Chair, and committee members. For the record, my name is Justin Fiore, and I'm here on behalf of the Maryland Municipal League in support of House Bill 1226. We were pleasantly surprised to see this bill introduced, and I want to thank the sponsor for highlighting this barrier to municipal incorporation. We haven't had a truly new municipal incorporation since the mid-1950s, and part of that can be attributed to the veto authority that counties have before a referendum, a vote can even occur. The core of our argument here is that connection between our right to self-governance and choice. In Maryland, municipalities and counties are two equal but different forms of government. Neither supersedes the other. And while there are pros and cons to each form, it's the residents who live there that should be given the choice on their government, the who and how they're represented. And this veto can take that away. It takes away the voices of residents who may not feel like the current system is working for them. Now, the intent of this bill isn't to strip that power entirely, but instead to provide a clear path for referendum based on a higher initial threshold of support. And that makes sense. At the end of the day, it's about defining a critical, unignorable mass of residents who simply wish to use their exercise their choice to be governed differently by a simple majority vote. And with that, we urge a favorable report on House Bill 1226.
Mike O'Hearn, welcome. 2 minutes. Mike, you there? I guess not. Hold on, folks.
Good afternoon, Chairman.
Oh, is Mr. O'Hearn here? Oh, there you are. Okay. Please, welcome to the committee. You've got 2 minutes. Thank you.
Good afternoon, Chairman Barv and members of the Environment and Transportation Committee and other attendees. I am Michael O'Hearn. My family and I have lived in Edgewood, Maryland since 2000. After retiring from active duty in 1994, I became involved in the Edgewood community through to the present day. I've been involved in varying capacities with nonprofit Neighbors in the Community of Edgewood, known as NICE, the Maryland State Police Athletic League on their executive committee, the Harford County Heroin Task Force, Aberdeen Proving Ground Edgewood Area Restoration Advisory Board, Edgewood Community Advisory Board, and in partnership with my lovely wife, co-founder of the Edgewood Community Gardens. In these intervening 25 years since my retirement, I have witnessed the impact of a negligent county government on my community. To date, 2 economic community development studies of Edgewood have been completed, which have resulted in no meaningful outcomes for this community. Monies have been removed from large capital projects for our area and sent to other areas of the county. Bipartisan opposition to the unneeded development of Abingdon Woods has been ignored by Harford County government, seemingly to the future detriment of the region. 25 years and more of a pattern and practice of placing the needs of this community last must come to an end, Chairman. Without reservation, I support HB 1226, and on behalf of my fellow community members, I ask for a favorable report on HB 1226 from the committee. Thank you for your time.
Thank you. Just to have you know that I wasn't playing hooky from the committee. That was my wife telling me that we never filled out a screening report for the apartment that we are renting. And so interesting to know. Okay, so questions. Looks like Delegate Ruth has a question.
Thank you, Mr. Chair. And thank you, Delegate Lasante. I think this is an interesting bill, and I certainly can see the tension between people in a community that feel like they're not getting the resources from the county. And I'm also a big supporter of representative democracy. However, I also have some concerns and questions if if this bill were to pass, it would cut the counties completely out of the decision making and leave it completely in the hands of the citizens. Whereas the counties may have a big picture view of things, of how something like this could impact everything from education to fiscal to environmental policy, that the citizens may just not have. So how could the counties continue to have input in that and ensure that the needs of all citizens are met if this were to pass?
Thank you, Delegate Ruth, and I really appreciate that. One of the pieces that I left in the bill is the very detailed report that the county government must do once they receive for annexation, to create a municipal corporation.
Okay.
And that report details that type of information. So unlike other referendums that we send to the voters, they're not required to have a detailed benefit analysis, and that is part of the law. And if my bill passes, that will still be part of the law. So that gives that type of information so that voters can be educated as to whether this is good for the community or not. So thank you very much for that question.
Thank you. And is there any kind of publication requirement or anything that would get that report?
Absolutely. Yeah, that's all done, that's in current law.
Thank you.
Let me interrupt the questioning. Apparently, I skipped over a person who wanted to testify in favor. So, John Guthrie, let me apologize to you. And you've got welcome to the committee. You've got 2 minutes, and then we'll resume the question. So I apologize for skipping over you.
Okay.
That's quite right, Mr. Chairman. I thank you very much. And I also thank the Environmental Transportation Committee for an opportunity to express my views. My name is Dion Guthrie. I live in Joppatown in Harford County. And I also served on the Harford County Council for 12 years from 2001 to 2014. And 8 of those years I served with Mary Ann Lasanti. She was on the council at the same time. I was on one end and she was on the other end. The significance of bringing that up is the fact that Edgewood was part of my district, Edgewood and Joppatown, as Andre now represents. I've represented that for 12 years. I fought for those 12 years to try to get Edgewood incorporated for a lot of the same reasons that you are hearing from some of the people that give testimony. It's been on my bucket list for years, and I'm so glad to hear that we're trying to move this forward. Edgewood's always been treated as kind of the stepchild of the county and not getting the things that they really needed. And as Andre said, to talk about the hotel tax, which I supported, raised about $2 to $3 million a year. And over 80% of that $2-3 million a year is raised in the Edgewood area where the bulk of the hotels and motels are. And over that period of time, the last 6 or 7 years, raising $2 or $3 million a year, 80% of it comes from the Edgewood area. Edgewood has gotten zero, not a single penny out of the hotel tax, though they're raising 80% of the money. So that really is a thorn in my side. So I'd like to thank the chair and the committee for this opportunity, and I hope you can give a favorable report to HB 1226 as I support it. And I certainly will answer any questions if anybody has them. Thank you.
Yeah, again, I apologize for skipping over you, Mr. Guthrie. So let's go to Delegate Clark, who has a question. Gary, you're going to need to unmute yourself.
Thank you, Chairman. Just a couple questions for the delegate sponsored the bill. Harford County is, I assume, is a charter government?
Who's that question to?
The delegate.
The sponsor of the bill. Delegate Santi, are you there? Well, I think Harford County does have charter government, doesn't it? I mean, has county.
I could answer that. Now, there are actually three incorporated in Harford County now.
There she is.
Okay.
Developer, I apologize. I am literally in 2 hearings, trying to do a bill hearing in the other, but I'm sorry.
Yeah, you might need to turn off the volume on the other one.
Got it. I'm sorry. Sorry, Mr. Chairman. Thank you.
My question was, I assume that your county, Harford County, is a charter government?
Yes, we do. We do have a government.
That consists of the county executive and how many council districts?
We have 6 council districts and a county council president.
And a county council president. The county council.
Correct.
Runs at large through the whole county?
Yes, that is correct. And each of the districts run in district. We changed that by county-wide election 18 years ago.
Okay, so the county council person represents the area that you have here that's being talked about is just one individual?
That is correct. That is correct.
And you feel that one individual doesn't have the wherewithal to bring the resources back?
Well, that's always been the challenge. It takes 4 votes to change zoning, to set budgets and things like that. And so you need to convince, you need your vote and 3 others, because when you voted at large, everybody had to stand for election at that time and represented that particular area. Now in district, you have 1 person.
Yeah, so if they actually, the council people all ran at large, actually, you would probably get better representation?
Well, that election, that was represented, that was decided by the voters of Harford County.
Well, I know that, but I'm just saying that there would be a possibility you get better representation
Well,
through the whole county.
Well, your question
Maybe.
might actually not be on the bill, but
yeah, I mean, you know,
Well,
I
thank you,
can't
Mr.
go
Chairman.
back in time. I
Yeah,
can't go back in time, but I can tell you that having partners at the municipal level does enhance our ability to represent our citizens with partners.
well, thank you, Mr. Chairman. I was wondering how long it would take you to catch on to what I was referring to. Trying to set
I
up.
was distracted by one of Delegate Amprey's emails, so
Yeah.
we'll blame him.
Okay. Well, thank you
Next question goes to Delegate Weigel.
Thank you, Mr. Chairman. I guess my experience from our county is I often hear the complaints of double taxation when you have the municipalities competing with the counties and vice versa, and not getting their fair share of tax credits and all that. And I heard several folks testify in regards to not getting a fair share of hotel motel tax. So if this bill is really about trying to get an equitable distribution of hotel motel tax, why don't you just introduce a bill to try to accomplish that rather than try to incorporate as a municipality? Or did I miss the point on some of the testimony?
Anybody have an answer for that?
Yes, this is
Councilman?
Councilman. Yes, sir. Thank you very much. I don't think that, I think that was just an example that we were giving based off the time that we had, but there's a multitude of issues that go along with not incorporating. So that's my answer.
By the way, I have to confess to something here. And during my 8 years on the Ways and Means Committee, it was my objective to get the hotel motel tax for Gaithersburg and Rockville, but I just couldn't figure out a way to do it so that only the two of them would get it. And I think there was some municipality on the Eastern Shore someplace, and I think Harford County got one as well. So guilty as charged. Sorry about that. Any questions for the witness or?
I think the other gentleman wanted to respond as well. He has his hand.
Yeah, sure. Go ahead, Mr. Guthrie.
Thank you, Mr. Chairman. I just wanted to touch base with that last delegate, what was talking about the hotel motel tax. That is just an example. However, understand that Harford County right now has 3 municipalities in it as it exists. Aberdeen is a municipality, Havre de Grace is a municipality, and so is Belair. And the biggest problem, Edgewood is the largest contingency of population in all of Harford County with 26,000 people, with a great deal of them minorities. And over the years, on the 12 years I spent on the Harford County Council, it was very difficult getting money into the budget and get it to funnel into the Edgewood area. But there are 3 municipalities in Harford County right now.
Okay, any other questions? Okay, seeing none, let's go to the opponent of the bill, Mike Sanderson with MACO. Mike?
Thank you very much, Mr. Chair and committee members. I'm Michael Sanderson with the Maryland Association of Counties. We've submitted written testimony on the bill, and I confess I don't have any real insight into the issues in Edgewood and in that part of Harford County. This is a statewide bill, and it's a statewide policy, and I think your questions have already led. Let's cut to the chase. So the central question here is, why would anyone who doesn't live in the area that's thinking about incorporating, why is it anybody else's business, right? Why does there need to be a step in the process where somebody else has something to say? So I'll try and address that, starting with the wheelhouse of this committee and working my way down the hallway. Number one, land use. Once someone's in a municipal area over a period of time, that becomes the governing body for land use decisions. We have seen with annexation policy in the past that, especially in a hot real estate market, developers want to build. They're frustrated that the county has pesky things like adequate public facilities ordinances. We're worried about school capacity and things like that. But if you work your way into a municipality, you can do an end run on county zoning and overcrowd the schools, whether the county likes it or not. Same thing could happen here by allowing people to draw themselves an oval and declare themselves a municipality. You end up with that concern as well, because municipalities don't have to abide by those. On transportation and particularly highway user revenues, a subject this committee is familiar with, like it or not, municipal roads are rewarded more generously through the state gas tax than are county roads. So simply drawing boundaries and declaring a municipality means more money comes to that area for maintenance of their own roads. And actually, that money comes out of the pocket of other municipalities. So Gaithersburg and so forth would be the ones whose ox would be gored by that decision. And finally, and probably most profoundly, under Maryland state law, local income taxes, 1/6 of the money goes to the municipality where people reside. So if you pass a bill like this that's statewide in any area, not just Edgewood, but any area can incorporate just by say so, you are inviting every wealthy enclave in every section of Maryland to say, you know what? We're sick of paying our money for your schools and your services over there. We're going to draw a boundary and keep the money right here, even though there might not be any need for public services or anything to be provided by the municipality. They could just be in the business of giving tax rebates back to their citizens.
If you could wrap up, that would be terrific. Although
Yes.
I think you made your point, so.
Okay, broader practical concerns with the bill on beyond, I think, the sympathetic case for one area in Harford County. That's why we don't think taking out a second voice in this process makes sense.
Okay, Delegate Healy has a question. Another
Thank you very much.
means refugee.
Yes, that's right. Well, actually, Mr. Sanderson was waiting staff my first year in the legislature.
Fellow refugee.
So he's also an exile from Ways and Means. Anyway, my question, as you probably know, I represent a district with 7 municipalities, and I was on a city council before I was in the legislature, and I'm very familiar with the whole system. When that very first term, when I was in Ways and Means, it was an issue that I asked about. And I was told, and I think it's true, that the counties were given this authority in the 1950s, shortly after New Carrollton was incorporated. And that New Carrollton was a town that was built entirely by a developer who worked to get, instead of having it be an HOA, which is what they do now, he helped to get it started as a town. And at that time, every time a group of people wanted to incorporate, they would come to the state legislature with a bill to do so. And what happened was they created this situation where they gave the counties the authority instead of the state legislature to make those decisions. And we've seen since the 1950s that the counties are loath to give up any authority to them. What this bill does, as I read it, is it doesn't say that they can do it anytime they want. It raises the threshold from 25% to 40%, and it requires a referendum. So it isn't like and it would be a referendum, I would think, of not just the people that are requesting it, but also of the rest of the people in the area there.
The counties are just not going to give up.
The boundaries are, but there are lots of ways that this could be done. And the question to you is, what would you do to increase the number of municipalities in the state? Or does Mako never want to see another municipality?
All fair questions, Delegate. I think that the only bone I would pick with the question is the referendum that's required under the bill is just for residents in the area proposed for incorporation. So if you live next door or across the county or affected in those direct ways, you're not part of the decision making if this bill were to pass.
Okay.
So that said,
fair enough.
Yeah. So on the broader question, I think local issues make it to the General Assembly all the time, and sometimes they raise a giant statewide policy that needs a correction, and sometimes they're local issues. I don't claim any expertise about Edgewood and that area of Harford County and whether the argument for incorporation is more persuasive than being a business improvement district or a special taxing district or other things that you could do to provide extra services or benefits to those residents. There are things you can do short of incorporating to serve an area. I live in one of those areas here in Anne Arundel County. So I don't know what makes sense for them. I just think that
being a municipality makes sense for them.
And if those residents say so, there ought to be some process where stakeholders beyond them, but who are affected by that decision, would have that input. In theory, you could make this a giant referendum for the entire county, or put it in the Constitution and put it before the entire state. What Maryland's elected to do is put that before the elected representatives in the county in which the proposed incorporation is to happen. I can't say whether that case is a compelling case. I don't know what the Harford County Council has done in the past, but this bill isn't a Harford County bill. This is
I understand
for all
that
areas.
for sure. I understand that for sure. I've been thinking that there are at least 2 counties that have no municipalities at all. And if you count Baltimore City, that makes 3. So, but Baltimore City is itself also a municipality. So, but Baltimore County and Howard County have no municipalities, but they have large communities. And that's what's happened. One of the things that we've got instead are these very large community associations where the people who live there don't necessarily have the right to vote. It's the landowners and the property owners and the unit owners that have the right to vote.
Yeah, so 18th century. Huh?
Thank you.
Mike, I've got a philosophical. Well, actually, let me say this: would Mako have opposed this bill if the referendum were countywide?
I don't know, honestly. I can't tell you. We take our positions through a legislative committee of elected officials. They voted on this bill. I really don't know what our conversation, how it might have been different if it had been a different structure. Fair question.
So the proponents of the bill make the point, and you make some very good points about wealthy enclaves, I have to say, but the proponents of the bill made the argument that not since the 1950s or something has a municipality come into existence. And so that means even older than me. So not older than Barry Ciliberti, but older than me. Is Barry there? Is he awake? So, I mean, it's a good point. I mean, right now, no county ever agree to a municipal government, and that seems to be kind of extreme to me. Comment about that?
I mean, I guess my only response is I'm not sure that in the whatever, in the several decades since that law was passed, I'm not sure that county governments have been barraged with 200, 300, 400 substantive, important, well-supported petitions from components within their county saying the only thing that'll help us is incorporation. I'm not sure that that's the.
Well, the reason they wouldn't be is because it's an impossible task. It's sort of like building a second bridge over the Chesapeake Bay. It's utterly impossible. Isn't that right, Delegate Jacobs?
Stay out of Rock Hall.
Okay, I see no further questions, but I did try to use this as an opportunity to entertain my committee. So I apologize, Delegate Lewis-Santee. All very good thoughts.
Thank you.
So that concludes the public hearing on House Bill 1226. Thank you so much.
Mr. Chairman, thank you all very much. I literally took a break, went to another committee, did 2 bill hearings and came back. So I apologize if I missed any direct questions.
Put in for some overtime pay, will you?
Thank you all very much for your consideration. Much
Okay.
appreciated.
Let's go to House Bill 1239. Delegate Learman.
Great. Hello, everybody. Thanks for your attention today. It's been an interesting day of bill hearings. So I am here with House Bill 1239 to create a financing program for some homes. So, we in Maryland are very lucky to be an old state with great history. But unfortunately, that also comes, older buildings cost more to rehab. And many of these older homes, around the state, Salisbury, Hagerstown, Cumberland, Baltimore, Annapolis, all of, and other areas as well, of course. Many of those homes that are in need of rehab now are in low and middle income neighborhoods. They're often neighborhoods that were once redlined through FHA's infamous maps. And it's very difficult to rehab, renovate, or rebuild these homes without additional financing support. The numbers just don't add up for private developers. So what happens then is that, many neighborhoods around our state are riddled with vacant and unsafe houses. And these neighborhoods are declining because there's just no way right now to earn a profit off of rehabbing many of these houses to sell or to sell them. So this bill expands the necessary tools that HCD can offer to make available to affordable housing developers who are working in low income areas to provide affordable and acceptable housing options to low socioeconomic Marylanders. What it does is it establishes a program and a fund within the Department of Housing and Community Development to help close the appraisal gap that often exists in properties when the construction expense to renovate or rebuild exceeds the sales price. So the financial assistance can be bundled, of course, with other funding from state, federal, or local private sources. And the fund will help ensure that properties in these low and middle income neighborhoods around the state are able to be rehabbed and really reborn. And that, of course, leads to more prosperous neighborhoods, more safer neighborhoods and communities all over the states. So I won't go through all the details of the fund. Just suffice to say that the program, this fund, it will make it possible. It is not possible right now, and it is not occurring at nearly the rate that we need. Rehabs and renovations are not occurring at nearly the rate that we need them to occur in order to revitalize some of these neighborhoods. And this program will make it possible for developers to construct or renovate residential properties, knowing they'll be able to sell them at an affordable price without having to invest more in the development than they would be able to recruit through the sale of the home. And I think, prioritizing the expansion of access to home ownership, we've been hearing a lot about the problems associated with renting, which we need to prioritize expanding access to home ownership. And this bill will help do that as well. So it will help in neighborhoods around the state. And I'm really excited about some of the folks who are here to talk to you about the work that they're doing and how they can't always do the work that they want to be able to do because the money just isn't there and the dollars don't add and the equation doesn't add up. So I ask for a favorable report. Thanks for your consideration.
Okay, let's go to, by the way, Ann, is your hand up from the last bill? Okay. The following people have signed up in favor of the bill. Dan Ellis, Natasha Mayhew, Sean Klosky, Bree Jones, Stephanie Prostel. That's it. So Dan Ellis is first, Natasha Mayhew's on deck.
Good afternoon. Thank you, Chairman Barve and members of the committee. I'm Dan Ellis. I'm the Executive Director of Neighborhood Housing Services of Baltimore. I'd like to extend my thanks to Delegate Learman for bringing this issue to the forefront and for her leadership in moving this forward. So in Baltimore and around the state, we often find that when we look to work in communities that have been historically disinvested, that the cost to acquire, to renovate, and to sell a property far exceeds what you can sell the property for, making it so that home ownership is not an option in those communities. It results in one of two things happening in those communities. Either no development occurs at all, which has often plagued some of our communities in the state, or there's limited work done that's often done at a substandard level or with no permits pulled at all. And this results in housing that then is rented out to people and creates a lot of problem with the housing stock. The proposed bill will help make it possible for developers who are responsible and bringing about homeownership outcomes to be able to do the work and still be able to do home ownership in areas that have been ignored by any development or any investment dollars for generations, oftentimes. And so we look forward to working together with our colleagues around the state and with the delegate to help move this bill forward. It will help make quality housing available for residents across the state and will bring about investment into these historic areas that have been disinvested. So we look forward and urge a favorable report on House Bill 1239. Thank you very much.
Thank you. Natasha Mayhew and then Sean Klosky.
Good afternoon, Chair, members of the committee. Natasha Mayhew here on behalf of the Mayor's Office and Mayor of Baltimore City in support of House Bill 1239. Baltimore City is committed to equitable development, and we are working very hard to put into place a community development framework to focus on minority and historically disinvested areas that have suffered historically under local, state, federal laws or policies. So to help rectify this disinvestment, we have started to make some changes, including launching a community catalyst grant program. And this program provides operational and capital funding to small developers that couldn't get financing or a seat at the table. For example, it could cost $300,000 to renovate a house that may only sell for $150,000. And lenders want to know that these developers can repay the loans when they go to sell. So it's really critical in the early stages of this development and rehab to provide them with the support necessary to close that appraisal gap. And this is especially important in our neighborhoods that have been historically underinvested in and where they feel the gap the most. So a state appraisal gap program as proposed by this bill would leverage city and other resources, significantly increasing the number of vacant and underutilized properties that we can restore. And these restored properties would, not only revitalize our communities and improve access to home ownership in those communities, but also increase the city's tax base. So we thank Delegate Lehrman for bringing this bill forward and urge a favorable report on House Bill 1239.
Thank you, Natasha. Next, Sean Klosky.
Good afternoon. My name is Sean Klosky. I'm with Rebuild Metro. We're an organization that's invested over $100 million into Baltimore City. As a result, we've eliminated over 700 blighted and abandoned properties and created a 550% appreciation in the neighborhoods we've invested in without displacing a single family. This whole issue is an appraisal gap issue, but it's not just a Baltimore issue. I think the state really has to understand that our experience tells us something important about what's happening statewide. And essentially, when you have an appraisal gap, the public support is necessary to entice private money in. Just as Dan said, unless you have the two working together, you won't resolve the issue and communities will become more and more stagnant and the problem will grow. So the question I would ask if I were you is, well, what's the root of this? And really the root of this is looking at the differential between the value of houses and the cost of houses. So you right now have 190,000 homes in the state of Maryland that are vulnerable to this issue, meaning their price right now is significantly below the cost for a substantial rehab. And it isn't just in, you'd think, oh, it's probably just in a couple of areas. No, it's actually a problem driven by a couple of factors. One is communities that are historically built out. They were built out in the 50s. So you're looking at communities in Baltimore City, Hartford County, Baltimore County, Montgomery, Prince George's, all of those together generate about 500,000 houses that were built 70 years ago or more, right? The next piece you have to ask is, well, how about homeowners? How long are they living? And you can think about moms and dads that live for decades in a house. Well, about 14% of all Maryland houses are in that condition. Those houses need to be reinvested in a much faster rate than they're currently or have been for the last 30 years. That's what's creating the problem, and this bill will help resolve it.
Okay, thank you very much. Next, Bree Jones, followed by Stephanie Prostel.
Thank you to the Environment and Transportation Committee for giving me the opportunity to testify, and thank you to Delegate Learman for co-sponsoring this bill. I'm here in support of the Appraisal Gap and Historic Redlining Financial Assistance Program. I'm going to briefly read a deed restriction for a house sold in College Park in PG County just 80 years ago when my grandmother was 10. Subject to the covenant that the above described property for any part thereof shall never be sold or conveyed to any Negro or any person of the Negro race or having Negro blood. Redlining in combination with blockbusting, contract lending, and urban renewal, in which Black houses were demolished to build highways, were a decades-long process still ongoing that systematically robbed and continues to rob Black Marylanders of their wealth. My name is Bree Jones, and I'm the founder of Parity Homes, which is an equitable community-led development company that removes systemic barriers to create space for people to authentically and equitably rebuild historically Black neighborhoods through collective economics. We use a simple but innovative approach to revitalizing hyper-distressed neighborhoods by creating pathways for existing and new residents to collectively buy homes together on a block-by-block basis. Yet in 21223 and 21217, where I work, our neighborhood is one of the most economically distressed areas in Baltimore, not only because of historic redlining, but because of a persistent issue called the appraisal gap, which is a unique phenomenon in historically redlined communities where the cost of development to renovate a building severely exceeds the appraised after repair value of that building. And so this bill provides a way forward to begin to heal those historic harms, revive healthy communities across the state, and create a pathway towards an inclusive and equitable Maryland where people can begin to build wealth and close the racial wealth disparity. Thank you.
Thank you. Next, Stephanie Prostel, and then we'll proceed to questions, I believe.
Oops. Great. Good afternoon, Chairman Barbe. Thank you so much for the opportunity to speak on behalf of Bill 1239. My name is Stephanie Prestel, and I'm the Deputy Director with Housing Initiative Partnership, HIP for short. We're a nonprofit affordable housing developer and counseling agency headquartered in Prince George's County. So just to reiterate what my colleagues have been talking about, the appraisal gap is very real, and it's not just Baltimore City. We work with homeownership primarily in Prince George's County, and we are facing the very same issues. The cost to renovate and purchase is far greater than what we can resell the home for in the communities in which we work. So just to give you an example of a home that we are purchasing on Friday, it's a small duplex that we're purchasing, and the appraised value is $172,000. It probably needs $150,000 in renovation. And when we sell it, the market value for that home will be maybe $225,000. So there's a significant gap that we need to fill to be able to renovate that home and get it back in the hands of a homeowner who can build equity and be established in that community. So we are very dependent on resources that can fill the gap. And this would be an excellent tool to help us do that, not only in Prince George's County, but in communities in Baltimore and the Eastern Shore and Western Maryland. We are all facing these issues to greater and lesser extents depending on our market. And obviously Prince George's County and Montgomery County are very expensive communities. So to create that affordable home ownership, this is a very important tool. So we strongly urge you to support 1239. Thank you.
Okay, thank you very much. We'll proceed to questions. First, Delegate Healy, then Delegate Wells.
Thank you very much, Mr. Chairman. My question is for the sponsor. I think this is a really great idea, and I really hope that we can find a way to make it successful. My one question, my concern is making sure that it truly is statewide. I know that there are a lot of needs in Baltimore. Years ago, when the historic tax credit was first started, all the money that was in that program got spent in Baltimore for years. And it was partly because the need was there. at least half of the properties that qualified were in the city. But more important, the developers from the city understood how to make use of it, and they got in line first, and all the money was gone before anybody else got it. And this happened for years. So before we go forward with a new program, I want to make sure we build in some kind of structure to make sure that the money is dispersed and it doesn't just go to one jurisdiction, because as the witnesses have said, that this is a concern that happens throughout the state. Delegate Learman?
Okay, I mean, there's nothing in the bill that would preclude, people from around the state. I think HIP and Stephanie, and others, I think we've come a long ways from when the historic tax credit first started in terms of the sophistication of developers and putting together different products to use different funding sources to make a deal work. I think, and so there are many more smaller developers and smaller affordable housing developers and CDCs around the state that can do this work now. So, I agree that it shouldn't all be coming to Baltimore. This is a statewide issue for sure. But I'm not, are you thinking like there should be a monetary limit, or I wouldn't want any portion to ever go unused either, of course. So right now, all it's administered by a state DHCD. We actually have an amendment to strike some of the language, but it would simply allow DHCD to bring in the applications and then approve. So it would be up to DHCD under this program to decide where the money would be going.
Okay, we'll work on that.
Okay.
Delegate Wells.
Open to ideas.
Thank you, Mr. Chair, and thank you to the bill sponsor. So I like what I'm hearing. I do have some questions, though. I guess my concern is we know the compounded effect of redlining, and we're still very much living through those, not effects, but actions today in which there is still a form of redlining that is being applied. And so my question or my concern is, how does this bill help address, or let me rephrase that. I'm concerned that we might still be rewarding people that still see Black and Brown communities as communities not worthy of investment for different reasons. And that we're still using the same kind of lens that was used during redlining. And so could this bill sponsor or other individuals on the panel, can you help me understand what part of the housing inequality and development inequality, what part of the equation would this bill solve? And if you can also just say, we also recognize that there's parts of it that it won't solve, because I just want to make sure that we're not seeing this as something that we're clear about the limitations of its impact.
Oh, yeah.
I think is what I'm trying to say.
No, it's an important point. This is not going to solve all the problems, associated. I think, there have been really excellent reports that have come out recently about the devaluation of assets in communities that are, in Black communities, right, and Black-owned businesses, and sort of there's a whole new, I think, academic look by Brookings and Andre Perry and others on devaluation issues, and this bill, doesn't address, much of that. This is just about one specific need to make sure that that affordable housing developers like Ms. Jones and Mr. Klosky and Ms. Prustel and others can make the numbers work to do the deals. And so they're not losing money on every house and ending up in bankruptcy, but so that they can actually do this development in a larger way. And I'm happy to turn it over to any of them to respond more about I think you asked, what actual piece does this solve? And so maybe one of them who actually do the work.
So I think what I'm hearing, because I am familiar with Good to See You, Bree. So this would really be focusing on more depressed pockets of areas of a community.
Yeah,
I guess is what I'm saying.
Right. This is like low and going into low income neighborhoods, right? I mean, there are a bunch of neighborhoods around the state, certainly in my district and yours and others, that are sort of teetering, right? And so this could help in those communities, and then it will also help in other communities that where there's, you know, rows of vacant homes that we haven't been able to put the money together to rehab and sell. So, you know, I think it can help in a variety of communities, some of which, and Sean and Bree are working in some of those communities now if they want to add something.
Delegate Learman, I'll just really briefly jump in. The bill specifically, the funds would only go into low and moderate income census tracts. And the bill empowers the DHCD to work with each local jurisdiction to identify specific targeted communities that most desperately need this type of funding. So I hope that answers your question, Delegate Wells.
And Delegate, this is Sean Klasky. I would also say, you know, our experience has been that this type of investment works best when it's focused and concentrated on a place. And that's why we were able to see such significant appreciation in the houses in the communities we were in. And these are almost the predominantly African-American community. And the idea was to create actual wealth by getting the market to move up. And again, the second part is not displacing anyone. So you're taking the units that are vacant or distressed where no one's living, you're making them the best units in the house, which pulls the entire market up, which is almost the reverse of when you're redlining or constricting capital flowing into a place, which actually drives the price down. The second piece would be sort of the entire concept or the construct of appraisal in general, and making sure that you have the right appraisers out there looking and saying, you know, this was a block that had 4 abandoned houses or 4 houses that were distressed, and it now has 4 houses that have just been newly reinvested in. That block has more value than the exact same block, say 5 years ago. And the difference is the intrinsic value. When you take the $150,000 worth of lumber material and you put it into 5 houses, that all of those families share in that investment. And that's the concept in this bill, is to direct capital at places to make the market benefit the families that live there.
Thank you. Thank you. I do have one last follow-up question, because I am familiar with Bree with Parity Homes' model, and there's a lot of other smaller, independent, and I think very community conscious, socially consciously driven housing developers. And so I think the one question that I do have that, and I feel like there may have been mentioning of this in the remarks by the panel, but I'm still very concerned because affordable housing is big business, right? We don't have enough of it, but the affordable housing developers make profit and they make money, and it is lucrative. May not be the same as the the fair market, but it still is. There's a bottom line, and there is profit. And so I'm curious to know if there's anything in legislation that's also focusing on targeting smaller developers, minority women business developers. If there's something in there that's targeting, folks that are coming in that may be like Parity Homes. There's another one I can think of in Baltimore. I can't think of the woman, but she's a carpenter. She's doing amazing work as well. But I think it's Black Women Build. Is there anything focusing on that? Because I do believe that a part of the equation that does yield what this legislation is seeking is when you have those community conscious, socially conscious developers at the table. So if anyone could just say that, and that's the last question, I promise.
There is not anything in the bill right now that would carve out for that, but I'd be happy to, if you have ideas on how to target it, I'm certainly happy to hear them. Yep.
And Delegate, there is an amendment that's being worked on right now about equity and making sure there's equity within the bill and tracking it and tracking requiring DHCD to track the pieces of that. So that's being
worked on.
Okay, but
that's right.
Not around tracking though, which is important. But one around, tracking is very important, but what I'm speaking to is an amendment around developers, because this is a pot of money that people are going to be chomping at the bit to use. So I'm now speaking to an amendment, or for us to have a discussion about that pot being targeted in some form fashion, whatever's legally able to be legally, that would target some of the conscious developers that really, that are the ones that are helping communities that have typically been redlined or discriminated against. They're the ones that are really doing that work.
One way to do that might be to limit the amount or the percent of the funds available to any one developer too, to make sure that there is, money available for multiple developers, so not just one is getting it all. I don't know, but I'm happy to talk with you about that for sure.
Yep, we'll definitely do that. Thank you.
Yeah.
Okay,
thanks.
let's go to Delegate Boyce. She has a question.
Thank you, Mr. Chairman, and thank you, Delegate Learman, for bringing this bill. I wanted to check in to see, is this companion legislation to HB 58 on the minority ownership work group?
This is, it is sort of companion, but this is also a cross file of a bill that Senator Hayes has brought. And so it's, this is certainly, I think, a lot of the work that we're seeing, I am very interested in home ownership and making home ownership more available. But this is, so I guess it could be considered companion legislation, but it was also the brainchild. I need to give credit to Senator Hayes.
No, thanks. Because, on the one bill we talked about kind of putting forth this task force to look at neighborhood revitalization and home household wealth equity, and now we're saying we're going to have a program for it. So I'm just wondering.
No, it's a great connection. And this is, I think, one of the pieces that we will find is necessary to make sure that we are creating more affordable, options, and that we are building homes in traditionally redlined neighborhoods that haven't been invested in, and creating affordable home ownership options as well. So no, it's a great point.
And I have one tiny last question. It may be relevant or unrelevant, but sometimes in this scenario, the opposite happens. And so you've got communities where you've got older structures and, the market around that community is going up. So it makes essentially a shell 3 or 4 times the cost. Like you think of somewhere before Utah Place was really starting to be developed, around the corner on like McCullough, for instance, Marble Hill of Baltimore. Those shells were they were essentially the buying price. And you get to people who bought them, thought they can rehab them, and then figured out, of course, not only did you pay more money for this shell, now you have to pay out the additional money to rehab it, which you don't have. And then what ends up happening is in those same communities that are teetering, you have an influx of property that is bought and then sold, and then bought and sold, because again, the price ends up being too high because of speculation 5 blocks over in these same communities. So I'm trying to figure out how potentially this bill somewhat addresses that issue as well, or maybe it's the same thing.
A good question. I don't know, maybe Bree or Sean or Dan or others or Stephanie might have additional thoughts on that scenario. I don't know. This would help small developer, this would help developers to make sure that if they bought a shell and they rehabbed it, they could make a little money off of selling it. So it wouldn't just sit a shell forever.
I understand. I'm talking about a current issue in those same neighborhoods.
Right.
Where speculation has driven up the cost of that shell.
Oh, right.
And keeping the community still in a dilapidated condition, because of course the actual cost of construction is way too high because the market price of the. So I think Mr. Klosky had a response.
We've been able to work with the city of Baltimore to do land disposition agreements in geographic areas, so that before we start, we have enough site control so that you don't have that problem. But you're right, the speculation is killer. You get half the neighborhood fixed, and then speculators come in and hold the other half.
And another piece to add is, as developers, as a nonprofit developer, we're often the first ones into a neighborhood to begin redevelopment, with the intent of helping the neighborhood market to work naturally and work effectively. And so as that happens, other developers can come in and can work there, because it's not about doing every house in the neighborhood. It's about helping the market to work in a healthy way for the residents and the environment, while also providing affordable housing options for those who have a need for that. So the program's not necessarily large enough to create enough revenue that it will lead to a lot of speculation, but it's really about getting the market to work. And this helps get it to that point. Once the market's working, then the natural development cycles can continue to function.
Okay.
Thank you.
Bree, I think they're calling you in the Senate. If you want to.
We have one more question from Delegate Harrison, and then I would like to move on to the next bill.
Thank you. Just real quickly, is there anything in this bill, and I think Mr. Ellis may have just answered it, but that would stop or prohibit those who are not nonprofit developers? I'm familiar with HIP, and if they're on the panel with Parity and Rebuild, I'm assuming that they're all the same, but let's just say there is, I don't know, some other organization or some other individual who goes in and buys and flips houses. Is there anything that prohibits them from coming in and taking advantage of these extra dollars moving on? And then the second part of the question is there a possibility then that as these properties get redeveloped, that the individuals who are already there still in the community end up getting priced out of their homes and then gentrification occurs?
Great question. Bree has to run to the Senate hearing, so I might let her speak briefly about the gentrification and the kind of
if
work
she has to go,
doing.
Stephanie is fine, because I
okay,
work.
Or Stephanie. Okay, Stephanie can talk about it. Yeah.
You know what? Let's move on to the next bill. I think you can find out offline. So,
Delegate Harrison, I'll follow up with you.
I'm happy to follow up with you too, Delegate Harrison. Thanks.
Okay.
Thank you, everybody.
That concludes the public hearing on House Bill 1239. Let's proceed to House Bill 1273. Delegate Conaway, welcome back to the committee.
Good afternoon, Mr. Chairman and committee. I'm Delegate Conaway here to introduce House Bill 1273. I know you guys are very interested in leases. So this is a bill that's dealing with a commercial lease addendum. What it says is that a landlord that violates the provision of an addendum to a commercial lease shall pay liquidated damages of $1,000 to the tenant unless a greater amount of liquidated damage is provided for under the terms of the lease agreement. And what you'll find is you're having a lot of leases that are being looked at now, especially due to the COVID, and things are in the lease and there were addendums made and all kinds of strange things are happening, provisions that are not even legal are being put in leases, as I understand it. So what this just says is if you have a lease and you have a landlord and you ask the landlord to sign an addendum and that landlord willfully breaks that agreement, then they can be responsible, or they could be responsible for $1,000 or more. And with that, I'd be glad to ask any questions that you answer any questions that I might be able to answer.
Yeah, nobody else has signed up in favor of the bill. So are there any questions for the sponsor of the bill? Okay, no.
Thank you. With that, I would request a favor.
And all the other written testimonies against, and it's all written, so there's nobody to question on that. So that ends the public hearing on House Bill 1273.
Thank you, Chair and Committee.
Okay, thank you, sir. Before I introduce Delegate Grammer to present 1282, I just want to remind you again, we're going to have a brief voting session after the public hearing, so don't wander off. Next is House Bill 1282, Delegate Grammer.
Thank you, Mr. Chair. Can you hear me okay?
Yes, I can hear you.
Thanks. I'll be very brief. For the record, Delegate Robin Grammer here to present House Bill 1282. House Bill 1282 puts in place a civil liability framework for rodent harborage. To be clear, when we say rodents in the context of this bill, we mean rats. Rat harborage is a significant and growing problem in my district and in many communities in the Baltimore region. It is a problem that is antithetical to safe and healthy communities. Rats spread disease and destroy property. They eat gardens, and if big enough, will even feed on family pets. If not dealt with, rats will create several burrows, one in a yard, and even spread across an entire block. This is an escalating problem that can become unbearable. Local jurisdictions use two methods to deal with rat harborage. The first method of dealing with the problem is rat eradication programs. These programs are costly, which makes their efficacy very limited. Few communities actually receive the benefit, and those that do only receive a temporary reprieve from the problem. And frequently rats return where actual harborage is not addressed. The second method of dealing with these problems is code enforcement. And part of the problem is, again, limited resources, which curtails the ability of agencies to enforce and monitor code violations. Limited resources combined with a protracted and sporadic nature of enforcement is ill-suited to handle chronic offenders. Community members who suffer rat infestations through no fault of their own should have a recourse to recover damages and hold accountable parties that are chronically bad actors. House Bill 1282 accomplishes this by defining rat harborage, specifying that the owner of the property is the responsible party, and stating that compensatory and punitive damages may be awarded. Two brief notes. I'd like to submit an amendment for consideration by the committee where the court could issue injunctive relief. And we have also been offered an amendment by the Maryland State Pest Control Association that would specify any treatments be done by licensed contractors. I'll leave that to the consideration of the committee. I'll close in saying rats have been a problem in the Baltimore region for decades, and they impact predominantly less wealthy communities. This is a solution that is long overdue, and we need your help. I'm happy to take questions, and I'd ask for a favorable.
Since no one else is signed up in favor to testify in favor, are there any questions for the sponsor of the bill? Okay, I don't see any questions. Thank you very much. Then let's go to the
Thank you.
Colby Ferguson and Lindsay Thompson in that order. Colby, you out there? Lindsay.
Chairman, hi. Colby is over on the paid sick leave bill, but I think probably cover both of our comments quickly here.
I bet you can. Go ahead.
So good afternoon, Mr. Chairman, members of the committee. My name is Lindsay Thompson, here today on behalf of the Maryland Grain Producers Association in opposition to House Bill 1282. We certainly understand and sympathize with the intent of the bill as presented by the sponsor. Our concern is that rodent, rat, and mice control in agricultural and rural areas is much different than it may be in the urban areas. So on our farms, we have things such as silos, barns where we store grain and feed, or we have animals. And then out in the fields, there are rodents that live in the wild, in the fields, and control of these rodents on agricultural properties is particularly difficult because the conditions such as shelter in a barn, the availability of food in the form of crops and feed intended for animals is not always something that's easily controlled. And if we are to try and use traps or also poison, that poses threats to potentially livestock and wildlife who may then consume those animals. And so we're concerned that this bill would open up liability and the potential for nuisance suits against agricultural properties where, again, as I mentioned, the control of these rodents is not quite the same as it may be in some of the urban areas. With that being said, if we were to be granted an exemption for property being zoned in agriculture or used for agricultural purposes, we would be happy to remove our opposition. Thank you.
Okay, questions for the witness? Seeing none, thank you very much. That ends the public hearing on House Bill 1282. Let's go to House Bill 1283. Delegate Wells.
Thank you, Chair Barbee. Members of the committee, I will try to be as brief because it sounds like I might be standing between us and voting. But for the record, I am Delegate Melissa Wells, and I'm here to present on HB 1283. Most, if not all of you have heard a story or have possibly been in a position at points in your life where your lease comes to an end. You might be struggling to pay your rent and you're waiting to see what your rent increase will be. In previous years, it has been as low as 1 or 2%, and which is something I think most of us can manage, even if it's a stretch. But there are at times years where it could increase, and has in the state of Maryland, by 5 to 7%, only with a 30-day notice. Your rental unit hasn't changed or has possibly gotten worse over the years you have been living there. You cannot find any justifiable reason for such an increase, but you know you cannot afford the increase. In the last months, you are stuck in a position that you cannot win. HB 1283 does have sponsor amendments, and so with those amendments, what this bill will do is it restricts landlords from raising rent more than 3% per year if the rental unit is 3 to 5 years or older, and less than $2,250 per month. This gives tenants the opportunity to think ahead and to know that at worst case, 3% is all the rent will go up by. HB 1283 includes additional rent increases if there is significant development around or upgrades to the rental unit. This was done because after speaking with individuals like the chairman and others that talk a lot about how rent stabilization has a negative impact on development, we did think about ways in which we could still show that we would be happy to address those concerns and that we would not be trying to specifically reduce development. So what it does is it will allow up to 2% rent increase for 1 year. So that means that it could be a total of 5%. And then for the second year, it will allow a 1% increase. So that means that it would allow for a total of 4% rent increase. And then the last amendment that we had is that it also puts in place a measure that rent cannot be raised more than 0.4% per year. If you are in a month to month, it cannot be raised by more than 0.2% every 6 months for a month to month lease. And that's during a state of emergency, if a state of emergency has been declared. This bill sounds somewhat familiar to some of you. That's because counties like Baltimore County, Anne Arundel, Howard, and Montgomery have passed emergency legislation, as well as Baltimore City. The number that they use, 3% number that we have, that number does derive also from testimony that MMHA provided to the Howard County Council that said that they would be able to maintain the necessary operations for the rental units at a 3% increase. So that was what helped me deduce down to the 3%. And then also in the Maryland Department of Housing and Community Development, their housing and needs assessment and 10-year strategic plan has identified the need for rent regulations to help limit annual increases and to also tenants be able to better predict. They have suggested that rent regulations should be something that we should be looking at. So I'm going to end there. But I will say, though, is that this bill is not rent control, because we are not actually seeking to restrict the actual rent that you can charge. We're simply looking at how you can at least provide some certainty around the percentage of the annual rent increase in the state of Maryland. Over the past 20 years, there has been a 34% increase in median rent. The majority of that rent increase has happened primarily from 2011 to 2017. So doing the back of the napkin math, roughly about a 1.5% increase in rent over that entire time period. So we gave that additional 1% just as a courtesy to the feedback from MMHA, and to, I think, provide some cushion for the landlords and for management. So with that, I urge a favorable report.
Hey, thank you very much. Why don't we go through all the proponents, and then we'll entertain questions. And they would be, in this order: Isadora Stern, Jonathan Rydell, Maryland Legal Aid, whoever that would be, Zafar Shah, Fabiola Lorenzo, Selena Benitez, and then there is a favorable amendment, Claudia Wilson Randall. So let's start with Isadora Stern with Jonathan Rydell on deck. Isadora, are you with us?
Yes, I am. Can you hear me?
Yep, and see you. You've got 2
Excellent.
minutes.
All
Welcome
right.
to the committee.
Thank you. Good afternoon, Mr. Chair and members of the committee. My name is Isadora Stern, and I'm here today with the Maryland Consumer Rights Coalition. MCRC is a statewide organization that works to promote economic inclusion and justice through our education, direct service, research, and advocacy. So even before COVID, Maryland was facing a housing affordability crisis. We were looking at 41% of Marylanders that are cost burdened, which means they're paying more than 35% of their income on housing. And now with COVID, we aren't just looking at this housing affordability crisis, but an eviction crisis also. Over 200,000 Marylanders are now facing eviction as courts are set to reopen. So this bill would help mitigate these crises by providing rent increase limits on certain properties, which would add much needed rent stabilization for our state. And rent stabilization is an effective way to maintain existing affordable housing and limit disruptions caused by rapid rent increases. There are counter arguments to rent stabilization laws. Some economists argue that it reduces the incentive to maintain existing housing or build new housing. But a lot of reports actually show that when these critiques are applied to real world examples, they become less salient. And they also often ignore other social benefits that are associated with rent stabilization laws, like neighborhood stability, displacement prevention, and inclusivity. Maryland doesn't currently have any statewide stabilization laws, but there are rent stabilization laws already in place in Tacoma Park, where we've seen a lower rent to income ratio compared to the rest of the state because of these laws. And like Delegate Wells just said, because of COVID-19, we've seen other jurisdictions pass stricter rent increase orders. So because of these examples, we've seen that rent stabilization is effective and much needed right now, especially as we move forward with the devastating effects of COVID-19. So thank you, and I would encourage you to consider giving this bill a favorable report.
Okay, thank you very much. Next, let's go to Jonathan Rydell, followed by whoever is up for Maryland Legal Aid.
Good afternoon, Chairman and members of the committee. My name is Jonathan Riedel, and I am a legal fellow at CASA. CASA is here today in strong support of HB 1283. We have tens of thousands of members who are renters, and many of them are just unable to keep up with the cost of renting. Our members, as Latino and immigrants, they are primarily low income, and they have also put down deep roots in their communities. So when the rent gets high, they cannot just pick up and move farther out. They cannot get government funded housing subsidies a lot of the times. They can't leave the rental market and buy a home. And perhaps worst of all, they can't fight rental increases when it's used as a weapon. For instance, when a landlord wants to circumvent the courts by raising rents hundreds or thousands of dollars to an above market rate. Instead, they do what every renter would do when they can no longer afford rent on their own. They double up. They live in overcrowded environments. They sublet. They rent out floors and rooms. As every landlord knows, these kinds of arrangements are a headache. Yet the problem is exacerbated the higher rents go. This bill would help ease the burden on renters and allow ordinary families to afford ordinary apartments and keep affording them while still allowing property owners to turn a large profit. Rent stabilization is both effective and popular. It will not damage the housing market as opponents frequently claim because we have numerous examples of its success. New York City has had rent stabilization for 50 years and developers continue to build and make handsome profits in both ordinary and rent stabilized building markets. Here in Maryland, as it was mentioned, Tacoma Park has had rent stabilization for 40 years. And if the developers' predictions in 1981 had come true, Tacoma Park would be an undesirable place to live or own property. But instead, its housing market is thriving and its average rents are modest. Tacoma Park's average rent is $1,450 per month, and 59% of housing is below $1,500 per month. For comparison, in neighboring Chillum, the same amount of housing is available below $1,500, but the average rent is $1,510. And in Silver Spring, the average rent is $1,639, and just 34% of housing is below $1,500. So you can see from these numbers that where rent stabilization exists, especially in populous areas, rents stay more affordable and landlords do not suffer a huge hit to their finances as they often fear. So we urge a favorable report given these benefits. Thank you very much.
Thank you. Let's now go to Maryland Legal Aid. Gregory, could it be you or someone else?
Mystery guest from Maryland Legal Aid, Gregory Countess again. Thank you very much, Mr. Chair and delegates, and thank you to Delegate Wells for introducing this particular bill, which we hope you give a favorable report. I mean, as this committee knows, Maryland's housing market underserves extremely low and low-income tenants, like our clients. Maryland Legal Aid, when it did a survey of its clients, found that affordable housing is the number one need and issue identified by our clients. And looking at a recent report that I'm sure you are all aware of, in that survey, it showed that over 167,000 Maryland families have severe housing cost burdens, which is defined as paying in excess of 50% of their income for rent. This bill helps to mitigate those issues. I won't go on for too much. I think that a lot of the points that I made are actually made in a written testimony and also have been made by some of the other folks who have testified. I would just simply say that, and as Delegate Wells did, that in the study commissioned by the state, there were a number of recommendations, and one of the recommendations that was made is that the state increase tenant protections, including other sorts of supports, and we believe that this falls dead center in those other supports that have been recommended by the report. And with that, again, we urge a favorable report. Thank you.
Okay, thank you. Zafar Shah and then Fabiola Lorenzo following Zafar.
Hey, thank you, Chairman Barve, members of the committee. Zafar Shah for the record from Public Justice Center. We are a member of the Renters United Coalition, Renters United Maryland, and testifying on behalf of Renters United Maryland. The committee is well acquainted that the coalition works to curtail eviction across Maryland. And in House Bill 1283, and we thank Delegate Wells for bringing this bill, we view the rent increase restrictions in this bill as an urgently needed but modest anti-eviction measure. There's been references to severe cost burden where households are paying more than half of their income towards housing costs. Prince George's, Baltimore and Montgomery counties, and Baltimore City account for nearly 525,000 eviction cases in fiscal year 2019. They also account for 70% of Maryland's severely cost-burdened households. And these numbers bear out what Public Justice Center's clients know rather acutely, and I'm sure this is the same for legal aids. You're lucky, and many of them would say blessed, if they can find a rental unit that they can afford, and they're devastated when that unit suddenly becomes unaffordable because of a rent increase. House Bill 1283 targets existing affordable rental housing. That's the Class C and even Class D properties that are older than 35 years in age. These are the properties that are available at modest rents. And the objective in this bill is to ensure that modest rents remain intact while also allowing landlords to increase rent to cover rising expenses. Even marginal rent increases, which House Bill 1283 allows up to a 3% annual cap, can be a struggle for low and moderate income renters. So this bill falls far short of the ideal, the utopia, but it's a practical tool, and it will be crucial in protecting vulnerable households from punitive rent increases designed to compel their move out. We urge a favorable report on House Bill 1283.
Thank you, Zafar. Fabiola Lorenzo and then Selena Benitez. Fabiola? Well, let's go to Selena Benitez. Okay, how about Claudia Wilson Randall? Well, I guess we're going to go to questions. And
no, Claudia Randall is there.
Oh, Claudia, if you could unmute yourself, we'd love to hear from you.
Sorry about that.
That's
was
okay.
Not being let in. Okay, so
Good afternoon, Chairman Barve, members of the Environmental and Transportation Committee. I just want to, there's been a lot of discussion from my colleagues about this bill, and I just really want to emphasize the need for the Maryland General Assembly to really figure out how we protect renters and implement strategies that expand opportunity for all Marylanders. It's critical that without market protections, significant policies that cultivate upward mobility and safe homes for all people in the state, we're basically creating an unstable housing affordability crisis. We've seen rents go up substantially throughout the throughout the crisis. In the last 10 years, we've seen significant policies where rents have gone up substantially in all but 3 jurisdictions in the state of Maryland. And this crisis is not about someone else. It's about our children. It's about our staff, the staff that work in the General Assembly. It's about millions of Maryland citizens seeking to rent apartments. And structurally, we're going to need to implement policies that help to secure the lives of renters across the state of Maryland. You have my written testimony, but I just wanted to emphasize a few points that also the sponsor did raise. The Maryland Housing Needs Assessment that was released, I believe on February 8th, is really a very important document. And we see where in the state pressure in the Washington suburbs, in the Baltimore, as well as suburban jurisdictions throughout the state. And I think that this bill and this increase in cap in increasing rent could be a very strong solution to a lot of our problems. My name is Claudia Wilson Randall. I am the executive director of the Community Development Network of Maryland, and I thank you all for allowing me to testify today.
Okay, did Fabiola or Selena show up, Trish? I guess not. So, okay. First question. Actually, I've got a question I'd like to ask because a number of people mentioned Tacoma Park. Are you guys aware that Tacoma Park introduced rent control in the early 80s, and the last time a new apartment building was constructed there was 1983?
Yes, I am, and I know I've learned more about that from you as well as other people. I think one of the things about Tacoma Park is part of the challenge, at least what we believe is part of the challenge, is that they use the consumer price index urban for Washington and Baltimore area. And so those numbers, they go up and down drastically. So for instance, it was at 2.7% in 2012, it was at negative 0.2% in 2015, and then it was at 2.2% in 2018. And so it saw those increases in fluctuations. I believe that creates some sense of stability. Also, Tacoma Park is, I hate to reduce it to size, but it is a I think it's like 2.2 miles square wide, or I forget how you say it correctly, but it's about 2-point-something miles wide. So I think
it's not huge. Yeah.
Having it, it's limited to a jurisdiction, municipality within a county. So I think when we look at the statewide, I believe that there's other factors that would be at play.
Okay, I think another thing that needs to be investigated is I know Montgomery County implemented rent control in 1978 and then repealed it in 1982, I think because no new apartments were built there. I think that's
so. This does not apply to new apartments, and I know opposition will say, well, that will still have an impact, but I think that opposition would look at any ability to help encourage and kind of guarantee reliability to tenants. I think they would be opposed to any of those things, to be honest, respectfully, Mr. Chair. So believe though that, hearing all that feedback, we do put in there language that does allow individuals to increase if there is substantial investment in a property. So I think there's a compromise that we can reach on this, in all honesty.
Okay. All right. Well, first, the questions are Delegate Ruth, Delegate Healy, Delegate Love, in that order.
Thank you, Mr. Chair. So you talked a little bit about the 3% and the thoughts about that, but I wanted to ask if you could elaborate on that a little more, how you came about the 3%, and also how you came up with 2250 as the cap.
Sure. So the 3% is based off of the average that we've seen in terms of increases in rent over the last couple of years. So in some counties, we saw the rent increase, like in Anne Arundel, in Wacomico, we saw that increase by 5%. And, those are somewhat of outliers, someone might say. At times, we have heard from tenants that there has been an increase of 7 to 8% of their rent. But for the most part, that increase has teetered around 1.5 to 2%. And so based off of hearing and testimony that MMHA provided at Howard County Council, and also thinking about, if there is some willingness to kind of, find a way to work with the management companies, that's at the 3%. So in all, realistically, it's really around 1.5 to 2%. And then we gave that 1% out of, good graces, I guess you could say. Delegate Ruth, what was the other question you asked?
I'm sorry, the other question was similarly how you came up with that 2250 as the number for the cap.
Sure. Yes, thank you for the question. So the 2250 that's basically focused on looking at the average. Well, one, when we pulled the data, average low income to low moderate income family, they were primarily living in homes that were built before 1985, and more or less the average rent was no more than $2,250, and that would be for like a single family or a 2-bedroom apartment. And so we were trying to also really look at what is the average housing costs, and kind of what does the average housing stock look like for individuals that would be struggling to access affordable housing.
Thank you.
Delegate Healy.
Thank you, Mr. Chairman. Delegate Wells, I have a couple of questions. When I just want to understand your bill, I'm afraid I haven't had time to read it yet, but if somebody buys an older apartment building like this, and there are tenants in it already, so that's part of why they buy it, how do they recoup their costs? Because if the previous owner owned it since, the 1960s, and all the mortgages has been paid, and they have very little investment left in it, and they're selling it at a good profit, the person who's buying it has a mortgage that they have to pay. So how do they get their money back? Is that addressed in your bill?
So what the bill does do is it does allow for so it allows a 3% increase annually. But what it does do is that it does allow, if there is investments that are made, it does allow rental increase in the first year by 2%. So that means that it would be a total rent increase allowable of 5%. And then the next year, it would allow a total rental increase of 4%. And that's investment. So that's how they would be able to
maybe that wouldn't be enough to recoup a big gap, though, I mean, I live in an older community, so there's a lot of buildings that people have owned for, 40 years, and they're getting old and they decide to sell them, and they may not have put much into them for a long time. Somebody buying them needs to invest quite a bit. They're not going to collect it back at 2 or 3% a year. What would the alternative be? I mean, I think I'm just looking at an unintended consequence. they could go out of the rental business for a while. They could get rid of all their tenants and do some renovations and then bring in people to pay much higher rent.
So this, I mean, I
This
think
whole
that
bill.
I think that the bill is seeking for those that want to maintain affordable housing. So if they want to do a complete gutting of the building, I mean, this bill only applies also to units that are at 2,250. So I think if I'm understanding it correctly, and this might be a question for us to have counsel help us hash out, but basically, if they were to do that and they would completely gut it and do an investment and they would go above the 2,250, then this would probably no longer be eligible.
But if it's in between, they could still get around the bill though, right? Even if they at the end of the day, it was not that high. If they did minimal, just enough to upgrade them to make them more.
I mean, I think the question, I think that if there's a significant investment, then I don't believe that this bill would apply to someone.
Okay.
But if it is
All
a
right.
smaller investment, which is really, I think what realistically folks, some segments of the market are doing, this is just helping provide some assurance that individuals will know when the rent's going to go up, because this bill won't solve displacement. And it won't solve, a owner coming in and buying a building and then doing a significant increase in rent. But what it does do is it would.
Oh, it does not deal with that. That was my question.
Yeah, correct. It does not.
Okay. All right. Thank you.
Delegate Love.
Thank you, Mr. Chair. Delegate Wells, in your presentation, you mentioned that this wasn't rent control, and I'm a little confused about the difference between rent control and rent stabilization. Why is this not a rent control?
So I think the way that folks are like in the traditional sense of using the word rent control, they're talking about a freezing of the rent payments, or that there's a freezing of the payments in a way that makes the landlord or management unable to increase the rent. And for that, there are strict rules. So in some cases, such as the unit can only be passed from family member to family member, or if that individual leaves, then there could be changes in how the rent is done. But this is not seeking to tell you how much your rent can be in dollars and cents.
Got it. Thank you.
Delegate Boyce.
Thanks. Delegate Love actually asked my question, because I also see the words interchangeably, rent restriction, rent stabilization, which could be a little wonky. But I want to go back to what you were talking about with Delegate Healy, and then I have another question. So you said I'm in an apartment and my rent is $800 a month.
Mm-hmm.
The landlord is required to tell me that they're going to increase it by 3% for the year. But then I thought you said that if all of a sudden he gets a loan, he's like, these apartments are like 40 years old, it's, linoleum everywhere, I want to clean it up. He does or she does the renovations. And so now let's say that happens in the year that I have already had my 3% increase. I thought I heard you said that the landlord could then charge up to 2%. So just for that year, in the year that my rent's going to go up 3%, and in the year that the rehab has happened, my rent will go up 5% that year, but no more than 3% every year after that.
Correct. So basically, because I think that what this legislation is seeking to do is the reliability of knowing how much your rent will increase by. But also it's not, I think that some will paint it that doing that means that investors and management companies or owners won't want to make any investment in the property. Hearing that feedback and taking that into consideration, we looked at the 2%. The 2% for the first year for substantial investments, appliances, floor, like modernization, whatever it may be. And so that's why it would apply that first year after it's been done. Then, you know, when you do the rent increase, it could go up by 2%. And then the year thereafter, you could still do an additional 1%. So it'd be 5% total the first year. And then you could do 4% the next year. And then it would go back to 3% thereafter.
So you can only charge a total of up to 3% in a matter of 2 years to recoup your cost for the renovation.
I think if I'm understanding.
Because you said 2 years the first year. You said,
Yeah, so it would be, yeah.
Yeah, let's do the math. Add the 1
Plus
carry
2
the
plus
3.
1, so 3% total.
3% total, but
Over.
only in a restricted 2 years.
Okay, so it would be, it's the.
No, I'm slow.
I know, I want to make sure I'm saying it so everyone, like we're all on the same page. So it's at 3%, that never changes. But that first year you could add 2% plus 2%, and the next year plus 1%.
Okay. Okay, so then my next question is if I'm a tenant and let's say that year, it's tight, could I negotiate to put off my 3% increase for the first year or the 5% if it's been rehabbed to the next year? Could I negotiate that with my landlord?
Our bill does not address that, but
Okay.
but that's an interesting concept that right?
I think oftentimes landlords and tenants don't really have strong enough relationships to be able to say, could we put this off next year? I'm willing to have a 5-6% increase the next year, but I can't afford it this year. I'm just curious about that. And then my last question, and if you've already answered this, tell me you already answered it, and I will just talk to you offline about it. Okay, so, and I think we talked a little bit about, I think I maybe heard the chairman say it, but like, okay, this passes, and I'm a landlord that has such a property, and I decide I'm going to essentially either sell the property, I think as mentioned before, or I decided that, you know what, I want a little less work. And so I'm going to, you know, do some gutting, do some rehabbing, and I'm going to turn these into condos.
Mm-hmm.
Would I be able to do that?
This bill would not restrict you from doing that, no.
Okay. Okay. All right, thank you.
Thank you. I think you're on mute, Mr. Chair.
Yikes, breaking my own rule. Thank you. Okay, well, we don't have any more questions, so I'm going to go to, and remember, I just want to remind everybody, we're going to have a voting. We have, I think, one more bill after this, and then we have a voting session, although it's a short voting session. So Lisa Jones, Grayson Wiggins, Catherine Howard, Lisa May, and Aaron Bradley in that order. Lisa Jones, you're first.
What?
Okay, Lisa Jones. Is Lisa Jones out there? No?
Can you hear me
Okay.
now? Here, can you hear me now?
Oh, Lisa Harris Jones. Oh, okay.
Yeah, me.
Yeah, okay, go
Yeah.
ahead. You've got 2 minutes. Welcome back to the committee.
Sure. Good afternoon, Mr. Chair, members of the committee. My name is Lisa Harris Jones, and I'm here on behalf of the Maryland Multi-Housing Association in opposition of House Bill 1283. I want to point out that I do know that this legislation was introduced with good intentions. However, even with the sponsor's proposed amendments, this bill would establish essentially statewide rent control for properties built before 1985 that are rented at a rate below $2,250 per month and occupied by a tenant that earns less than $150,000 per year. Current investment in properties built before 1985 is utilized to renovate buildings to offer better housing options and benefit the surrounding communities. Under this bill, even if it's amended to 3%, and I should point out that it was noted that MMHA agreed to a 3% cap in surrounding counties, but that was in the context of temporary legislation in response response to the current pandemic. So I think that's important to put up point. But armed with that knowledge that there's a cap of 3% and whether the 3% or 5% appears to be very complicated, it's going to discourage people from investing into these properties, and that money is going to go elsewhere. This rent control is not a new thing. It's been around since World War II. It failed twice in Montgomery County. I'm not going to go into the Tacoma Park, the event of Tacoma Park. The chair noted that previously, but even in Tacoma Park, where in Montgomery County, property values increased substantially, in that area, they remain stagnant. If you look at the testimony that was submitted by MMHA, you will see the other concerns that Towson University pointed out in the report when Montgomery County tried this. And I'm going to wrap up and just say that respectfully request an unfavorable report on this legislation, and I'll answer any questions after.
Okay, thanks a lot, Lisa. Grayson Wiggins, and then Catherine Howard is up.
Good afternoon, Mr. Chairman and members of the committee. Grayson Wiggins with MMHA. Within the field of economics, there is consensus agreement that rent control laws produce negative economic consequences. That agreement is a result of decades of research and empirical evidence that proves rent ceilings reduce the quantity and quality of housing. Simply stated, we are concerned that this bill will disrupt the marketplace and discourage investment in covered rental properties. According to a 2019 National Multifamily Housing Council survey, 34% of property owners that operate with rent-controlled locations have already reduced investment or development, and an additional 49% are considering doing so moving forward. The recently released DHCD report analyzes Maryland's housing market and includes 66 different quote-unquote toolbox options for Maryland, 44 of which are identified as benefiting both housing providers and tenants. We would be happy to work with the sponsor during the interim to review options in the report, but we cannot support rent control policies that have proven to result in negative consequences for both housing providers and tenants. One proponent noted that there are not real-world examples of the negative impacts. Simply stated, that is incorrect. For example, Stanford economists reviewed San Francisco's rent control policies, which capped rent increases at 7% for properties built before 1979. The report found that the San Francisco law and a change to it in 1994 that removed certain exempted properties resulted in 15% reductions in rental housing stock, led to higher income residents moving into the city, and resulted in rent control treated properties being more likely to have higher income residents than non-rent controlled properties. There's also, as Lisa noted, a great report from Towson University that covers this subject. For the aforementioned reasons, we respectfully request an unfavorable report from the committee. Thank you.
Okay, next, Catherine Howard, and then Lisa May on deck.
All right. Thank you very much, Mr. Chair. I'm Kathy Howard with Regional Management, Inc. We're a member of the Maryland Multi-Housing Association as well. I'll try to keep it short. Regional Management is a market rate operator of about a little over 5,000 units in Baltimore City and Baltimore County of the vintage 1960 to early 1980 properties. One of the things that was mentioned as a good point in this bill is that if you don't do major renovations, or if you do major renovations, then you will be able to raise your rent under the guise of this bill. Unfortunately, there are a lot of us that do not do wholesale renovations of our properties. We do this because we do one unit at a time. We renovate one unit at a time. We keep up with new things that are needed in the apartments. And unfortunately, it does not wind up being to the bottom line that would be reflected in this bill that would keep us from having to stabilize, quote unquote, our rents. This is not a sustainable bill. This is not a sustainable model for older rental housing to remain in good repair and in good condition, in a marketable condition. And we definitely do not think that at this particular time that this is at all a good idea. And it is with adamancy, I would ask for an unfavorable report on this bill.
Okay, Lisa May, and then the final witness will be Aaron Bradley.
Thank you, Mr. Chairman. Lisa May again for the Maryland Realtors. As was mentioned, there are academic studies that show that rent restrictions such as these actually do not create or maintain affordable housing. The San Francisco study was one that was mentioned, but there was also a University of Maryland study on the aforementioned Tacoma Park example. Their rental housing units decreased by 14%, and that is a total of 560 fewer rental units, even within small Tacoma Park. We see these ordinances just as motivation for landlords to pull their properties from the rental market to go get a tidy sum in the for sale market right now. And it will also disincentivize private owners from introducing new rental stock into the market. And that limits rental supply. It raises rents on the non-restricted units and essentially just creates a new category of renters who are now cost burdened and unable to afford rental housing. So for those reasons, we do ask for an unfavorable report.
Okay, and finally, we have Aaron Bradley.
Good afternoon. I'm sorry, you're right. Thank you. Good afternoon, Chairman, Committee. Aaron Bradley, representing the Apartment Office Building Association of Metropolitan Washington. The panel has shared a lot of information in our lengthy written testimony. It lays out a bunch of things, but as AOBA represents Montgomery and Prince George's County, I'll discuss Montgomery County's experience when it tried rent control in 1973 to 1977 and from 1979 to 1981. During these periods, no new rental units were constructed or planned despite very low vacancy rates. In 1980, Tacoma Park adopted a rent control ordinance, so we can look what happened with property values, right? County values increased substantially after the repeal of rent control, while desirably located Tacoma Park's property values have remained stagnant since 1980, as people mentioned. A study by Towson University's Regional Economic Studies Institute found that if enacted in 2015, by 2025, the county would have lost over $500 million in local tax revenue, thus jeopardizing the county's financial stability. Between 2015 and 2025, the loss of income from foregone construction projects and reduced employee mobility would have resulted in over 70,900 jobs unrealized, loss of $10.4 billion in county economic output, and loss of $5.4 billion in wages. In order to offset the fiscal impact of rent control with additional taxes, owner-occupied household property tax rates would increase an average of $267 per household. In this way, rent control picks winners and losers. Low and moderate income households, homeowners would face a direct negative financial impact from the imposition of rent control. Finally, in its economic impact statement dated December 2020, the Montgomery County Office of Legislative Oversight writes, economists generally conclude that rent control and stabilization laws generally do a poor job of targeting those with the greatest need, and often the benefits are inefficiently and inequitably targeted. The OLO impact statement also notes that there is evidence that rent stabilization—
You could wind up the committee.
Absolutely, sir. But I just want to say that the OLO impact statement notes that there is evidence that rent stabilization has led to neighborhood deterioration, as so many of my panelists have discussed.
Okay. We have a question from Delegate Boyce.
I thought I had a question, and yet I'm still wrapping my brain around it, but let me just throw this out there. If not rent stabilization, and if all these reports are saying they don't work, what then is the answer for helping folks stay in their homes without the burden of markets that tend not to meet the income of those very residents we want to keep housed? Aaron, you just mentioned, and I think you were at your time, but you mentioned, I think in your last couple of statements, that in certain stabilizations did not work because of implementation. You were wrapping up.
Sure. So one of the reasons that rent control often doesn't work is because it's not means tested. This bill attempts means testing with households at 150,000, and not to get into what is appropriate means or not, but 150,000 could certainly be, a a single person making 147,000, they're able then to make use of this and get into a rent controlled unit, whereas a family of 4 making 60,000 are not able to get into this and have to look for unaffordable options. I know that the DHCD study put out a number of suggestions, and the industry is also, like, we know that there's an affordable housing crisis. We're looking at it in Prince George's County, the Housing Opportunities for All task force, like working very aggressively at looking at how we provide affordable housing, but rent control has just been seen over and over again to be problematic and create other unintended consequences that wind up hurting the local jurisdiction, not necessarily helping the people that we want to help most. It also ties residents to units that they've outgrown, just any number of unintended consequences we've seen time and time again where rent control has been enacted.
And the only reason why I ask, because many may know or not know, my family landed in DC, and my grandmother lives in the same apartment building since before I was born. She is since retired, probably 15 or 20 years now. And I know DC is quite expensive right now, right? And so I have no idea what she pays, but I know she's still there, and I know they have rent control. So I'm always thinking, you know, every time I think about rent control or stabilization, I think about my grandmother and thinking, how in the world is she still there? And if it doesn't work, why is it working there? I mean, the elevator is shoddy, but that's another story. And maybe that's the pair off of it is that she's got good rent, but she may die every day in the elevator. But I guess I'm just trying to figure out, how does it seem to work in some places and not here? So I thank you for entertaining my questions.
Okay, the next question goes to Delegate Ruth, excuse me.
Thank you, Mr. Chair. I just wanted to follow up on Delegate Boyce's question. I appreciate your answer and the work that you're doing to try to figure out how to solve this affordable housing crisis. And that certainly we know is a big crisis, but affordable housing is only part of the problem, because as Delegate Boyce said, we don't want to just make affordable housing available somewhere else. We want people to be able to stay in the home that they've lived in for many years. And sometimes, gentrification can drive people out of the homes that they've lived in. So, is there an answer beyond the affordable housing piece of it? Is there an answer for the stabilization piece of it?
If I can answer, and I think it was touched on, the report that the DHCD provided, or we've been reviewing, actually had close to 60 or more options to address the concern with rent stabilization and to make sure that people can stay within their homes. And what's interesting about those options, they did mention rent control, but the concern with rent control was noted that out of all of the options, they noted that it discourages the investment in aging properties, and they do not target benefits based on need. So while rent control was in there, there were 61 other different ways to get to the problem that I believe that you and others are concerned with. And I think it's worth looking at that report to see if there are better options.
Thank you. And I do think I've heard that report mentioned several times, and I do want to take a look at it. And I know you can't tell us all 61 options, but are there one or two that you think are particularly good options?
So I'll throw that. I don't know if Grayson or Kathy want to address that. I don't have the report in front of me. I'm sorry.
Sure. Hi, Delegate. Thank you for the question. Yeah, as Lisa noted, so there are actually, it's a pretty cool report, and I'd be happy to send you a link.
Please send it to all of us.
Yeah.
Yeah, actually, if you could send it to the committee, I'd like to see it as well myself.
Yeah, absolutely. And so they actually go through, and there's 66 options. And the one that they note the critique with is the rent regulation, rent control piece. And there are 44 options. So they go through and they outline which option, if it benefits the property owner, the tenant, or both. And 44 benefit both. And there are some really cool ideas in there. There's ideas with trust funds and how we look at the price of construction and things like that. So there are a lot of cool options. I don't know that I can give you. I don't want to give you one or two now, and then later we think that number 20 or 23 is the better option. But there are a lot of really cool options in the report.
When did that report come out?
December.
Oh, of last year. Oh, that's why nobody's seen it. Delegate Wells has a question.
Yes, I have just a quick question, but because I listened to, I think it was Aaron, and it seemed like a lot of honing in on targeting, Aaron Bradley. So my question is, you know, is there, I guess, what is the appetite for looking at more targeting of how a stabilization could work? Because I get the impression that it sounds like there's this idea from many of your clients, this is kind of for AOBA, MHA, and the like, that the challenge is that when done broadly, there seems to be this kind of earthquake in the housing market, right? And so I'm wondering if there's any consensus that that impact could be limited, and the impact that your interest sees as an impact, negative impact, could be diluted if there was a way for us to target units or individuals when it comes to rent stabilization. So is that something that folks would be interested in exploring? Is there any initial opinion about the impact of something like that? I guess maybe Aaron Brett, you're the last person to go, not to put you on the spot, but I mean, I'm really just trying to get to the crux of it, because, if your testimony, if you're saying, well, when done broadly, it has a significant impact on the entire market and unintended consequences, then can we talk about how we can target those low, moderate income that are able to pay, but just cannot afford to see a 6% increase in their rent? And I know COVID is a thing, but people have been challenged before COVID, so.
Certainly. Sure, Delegate Wells, you didn't want to put me on the spot, but here we are.
You're real smart, Aaron. I have faith in you.
It's her job to be on the spot. Come on.
I will say that right now, so I will say that, speaking off the top of my head and coming up with targets, no, I can't do that. But are there ways that we can look at how we keep people stably housed? Certainly. I don't know what those targets look like. That would be a larger conversation that we would need to bring in people far, far more knowledgeable than me. Far more knowledgeable than me. Kathy's been doing this forever. She may know. But again, I do think that DHCD put out a really great report with 66 different approaches that we could definitely work through. I know that, investment banks to preserve affordable housing is also a useful way to preserve and create new affordable housing. That's what we're looking at in some local jurisdictions. All of those things are very useful in targeting, creating places where people can afford to live and be stably housed. But targeting this particular initiative, off the top of my head, I can't say what that would look like. But as you know, Delegate Wells, I'm always willing to talk to you some more about it offline.
Okay. I will tell you that I was miffed to not be the beneficiary of this. One of my uncles had a rent-controlled property in DC, and he also had a property in Florida where he was a tax resident, but he gave all his money to the University of Pennsylvania, so Kumar got nothing. So in any case, how do you give money to anyway? Okay, so that concludes the public hearing on House Bill 1283. We are going to go to our last bill before our voting session on one amendment on one bill, which is House Bill 1305, Delegate Ahrens.
Thank you, Mr. Chairman. It's always a pleasure, and thanks for saving the best for last. I really appreciate that.
It was just numerical order.
I'm teasing you. I appreciate that. I'm just finishing up my hearings as we speak. So, Mr. Chairman, I have House Bill 1305. It's mandatory insurance coverage alterations for condominiums. 1305 makes a small but important change to the Maryland condominium law that will help developers of more affordable housing units. The real estate market's changed over the last year, and you'll see that Maryland is experiencing a housing deficit, which is, if you're a real estate agent, it's somewhat of a good problem, but if you're trying to buy one, it's a little rougher. I think we're 11th in housing right now. 1305 will help in a small way, but the process for purchases of small affordable housing units built under a condominium regime, it'll make it more transparent and more similar to other detached properties. With me, I have Mr. Kevin Waterman and Mr. Bill Castelli. They're realtors with the Realtor Association. Kevin is the president of the Bay Area Association of Realtors, and they can discuss in greater detail the legislation as well as the cottage cluster type development that Mr. Waterman helped build on the Eastern Shore. So if you don't mind, I'll turn it over to them. I look for a favorable review. Thank you.
Okay. Testifying in favor of the bill, Kevin Waterman, Bill Castelli, Lisa May, Stephen Randall, and Robin Manugian. Nope, she's written. So basically Kevin, William, Lisa, Stephen. So we'll go through all of you guys and then we'll do questions.
Guess I'll go first then, if that's fine.
Kevin Waterman?
Yes, I'm Kevin Waterman. I'm the president of the Bay Area Association of Realtors. I also am with Coldwell Banker Waterman Realty, or a small brokerage on the Eastern Shore. I also do some small scale development projects. This came to our attention, this issue from a small community we did. It was 8 homes that are small single family homes, but due to the small lot size that we wanted to set them up on, the only viable way to do them was as a condominium. This in turn, it thought it would be a very attractive product, and in fact it was, but one of the big barriers we discovered is that due to the way the Condominium Act is structured, it says that all units of the condominium must be covered by the master insurance policy. First, this was a marketing issue for us because people looked at these and saw single family homes. They assumed the costs are like other single family homes. I need to have my taxes, there's the condo fee, and they also assumed they had to get property insurance, the same as a typical single family home, not realizing that that was wrapped into the condo fee. This made them think that, wow, this is really expensive to own, not realizing your property insurance is a lot less because your condo fee is higher. So that's the first thing, just helps make people understand what these cottage clusters, which are an important aspect of the missing middle housing that we are seeing today growing as a desired thing in America. 2 other benefits I want to quickly touch on. Most cottage home communities are small, seldom more than a dozen units, which means if even a single owner can't pay their dues, runs into trouble, that means that full cost gets shifted onto the other few owners, which imperils the insurance of the entire condominium. The other big benefit is it offers owners the opportunity to gain the discounts of bundling their what would then become their homeowners along with their car, whatever else they might have. So I think it's a relatively minor issue, but I think it offers a lot of potential benefits to the people of Maryland. Thank you for your time.
Thank you. Next up, Bill Castelli. Bill, you out there?
Yep. Thank you, Mr. Chair, members of the committee. Bill Castelli. I'll be very quick too. I think Kevin really covered it. There are only a couple of points I'd want to make, which are, a lot of the cottage cluster ordinances that we see across the country are done locally. This happens to be one of the areas that actually the state can get involved because as Mr. Waterman mentioned, some of these, even though they're single family detached properties, it makes a lot of sense to develop them under a condo regime because you can have smaller lots, smaller properties. And, when you have a master policy that covers all of the insurance for a condominium and they're all attached units, like what you would picture in an apartment building, having that master insurance policy makes sense. I mean, all of these units share walls, they share ceilings, et cetera. That's not true with a detached condominium unit, which is what we're talking about. These are freestanding, smaller properties, look exactly like a normal detached single family, only a little bit smaller. And so we think this helps consumers compare apples to apples because that's their expectation, is that it is a single family property. And we would encourage a favorable report.
Okay, thank you very much, Lisa May. And then following her will be Stephen Randall.
The hour is late, Mr. Chairman. I have nothing to add. Thank you.
Wow, you get the award. Okay, Stephen Randall. Steve? Well, okay. Are there questions? Delegate Healy has a question.
Yes, I do. Let's see if I can find my, oh, hang on.
Well, we could hear you, so obviously you did.
Oh, okay. Oh, that's good. Thank you very much. My question is about if this is built under the condo law, would they have like homeowners association or condo association rules and regulations and bylaws and all of that that go with being in a community other than the insurance piece that we're talking about here? Does somebody?
Yes, I can speak to that given our experience with the project we did of this nature, that it is a condominium in every respect of other condominiums. They have bylaws as council of owners. There is, in this case, a very limited common area elements, pretty much was mostly just the stormwater management, stuff that was there. But it is a condo in every other respect. The only difference is they are all detached single family units, not attached units, townhomes, apartments, whatever else.
Okay, so why should it be different? I don't understand. Why do you not want to have the same insurance like all the other? Like you have a townhouse condominium, it does the same kind of thing. So, but they have the insurance.
Well, the main value there is that, at least as far as I'm aware of it, is that when you have, your traditional things of what the Condominium Act envisioned, because that's what there was at the time, townhomes, apartments, they all share walls, which means that something that happens in one unit can very easily spread to affect things in other units, which means that if everyone has their own insurance, you have the potential of the insurance companies squabbling with each other about whose responsibility is it to cover this thing that happened. Is it the unit it started in? Is it the unit it spread to? Who covers what? So it made sense to put everybody in under the same insurance policy with the same provider. When you have detached single family homes, that logic doesn't really hold anymore because there's the capacity for spread is no different than it is in any other single family detached home where it's not considered a major concern.
You said that they're actually built very close to each other though. So isn't that like a fire?
Not particular. I mean, I don't know if it's possible for me to share my screen. I have some stuff I pulled up about that project that we did. I can show it.
Well, listen, it's getting late here. We're going to be voting soon.
Okay, that's fine.
That's fine.
But you can send us the document and we can share
I'm
that.
happy to ensure the committee gets that.
Okay.
Great, thank you.
Delegate Holmes.
Thank you, Mr. Chair. My first two questions only. My first question is: you seem to be focusing in on the construction type, meaning single family detached type of units. Is that what this is?
Yes, that is what this is focused on.
Okay. And so if this is and I recognize that a condominium and an HOA is a governing structure. It's not a construction type. We all know that, okay? So based upon your construction type, meaning single family detached homes, why did you choose a governing structure of a condominium as opposed to a homeowners association?
The reason for that is that in order to make homes of this size and that, where this was, worked, and for many other projects like this, the only way to make them financially viable is to go and do them on very small lots, which based off of, certainly the local zoning ordinances here in Queen Anne's County and in many other areas of the state, the only way to make those viable is to do small lots, which you cannot do under traditional. The only way you can get to units that small for lot size is to do them under a condominium regime.
I'm not getting it. Maybe I'll have to talk to you offline because like I said, condominium HOA is a governing structure. It's not a construction type. And therefore you could have, in my opinion, you could have done this under an HOA governance, but we'll talk about it offline because as indicated earlier, the hour is getting late. I would appreciate that.
Yeah, Marvin has forgotten more about this than I will ever learn. Delegate Terraza.
Thank you, Mr. Chairman. So in the zoning code, it says you can double the density and with a, if you use a condominium regime or you use a condominium regime to double the density and get around the zoning.
Well, it doesn't, I'll be honest, I don't remember exactly what the specifics were, but you are generally able to, because it falls under one of the multifamily definitions, you are able to achieve a higher level of density than you would under other classifications.
So that it actually speaks to a higher density in those, because I know in Howard County, it's used to get around the density requirement, the density limitations. That you can use the condominium regime to get around the density limitations.
I wouldn't necessarily term it as get around, but it is within the zoning code a means of achieving a higher density than you would via other ownership method regimes.
In the sense that you can figure out how to do it, but not in the sense that it says you can put in condominiums and double your density.
I'm sorry, I'm not quite clear on.
So in other words, it's not like, so I was on a zoning board for 12 years in Howard County, and it wasn't that we had in the zoning code, you can double your density if you use condominium structure. It wouldn't make any sense for us to say that. It's that so it's not like in their zoning code, it says, gosh, if you use this other governing structure, you can double your density. It wouldn't make any sense to have that in your zoning code.
Yeah. I mean, I would have to sit down and, once again, review through the entirety of the zoning code. I don't remember the exact full details. I definitely just need to remember that the only way that we were able to make this particular project viable, and some of the other ones we were looking at in terms of being able to achieve on lot sizes that are, fit the financial viability for homes of what that size could sell for, was to go and operate them as our zoning code is currently structured, is under the condominium regime.
Okay, thank you.
No.
Okay, any further questions for the proponents of this bill? Seeing none, that ends the public hearing on House Bill 1305, and that ends the public hearing for today, and it is 5:24, which is not bad. And we're going to proceed to a voting session.
Thank you, Mr.
Everybody who's not here, put your hands up. Just joking. Okay.
Very bad joke.
So we've got an amendment to the bag bill. And Dana, do you have this in front of you, or is it good for you to have Delegate Learman present it? Well, how do you prefer to do this? You need to unmute. Dana,
So
you need.
I don't have it right in front of me, so if Delegate Learman wants to present it, that's.
Yeah. Brooke, why don't you present the amendment, what it does, and or, I mean, I can just read from the report here. It just
Sure,
says,
I can. Yeah, I mean, I can tell folks the
Sure, go
genesis of the amendment. If you all remember when we had our voting session on the bag ban this year, had a discussion with Delegate Clark about the need to not treat farmers markets differently from pick your own farms. And so this, and I promised that I would work with him and Delegate Crosby on language for an amendment. And so the three of us worked together and settled on this language, with the bill drafters of DLS Counsel advising us so this language is about ensuring that farmers who grow produce and sell it themselves at a farmer's market or at a pick your own farm have the option of using a plastic bag. So it creates parity between, farmers markets, farmers who sell their own produce at a farmer's market and farmers who sell their own produce at a pick your own farm. And so thank you, Delegate Clark, for your good work on this, and also to Delegate Crosby. Thanks.
okay, any discussion or questions about the amendment? Delegate Boyce.
Thank you, Mr. Chair. So So this gives them the option, meaning that they could not choose the option until
Right.
bring their own SEC.
Yes, they could.
Great.
Yes, exactly. This just creates an exemption for them. Yep, exactly.
Okay, any further discussion or debate on the amendment? If not, we'll proceed to a vote. All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Okay, the amendment carries. The bills before us as amended. Any discussion on the bill?
Move favorable.
Second.
Any discussion, any debate, or should we just go to a roll call?
Go for it.
Roll call.
Vice Chair Stein,
Yes.
Holmes,
Yes.
Learman,
Yes.
Fraser Hidalgo,
Yes.
Otto,
No.
Jacobs,
No.
Weibel,
No.
Ampray.
Was that, we didn't hear you because you're muted. You can-
Yes.
Yes, okay.
Siliberti,
No.
Wells,
Yes.
Love,
Yes.
Ruth,
Yes.
Stewart,
Yes.
Layman,
Yes.
Harrison,
Yes.
Tarasa,
Yes.
Parrot,
No.
Boyce,
Yes.
Clark,
Yes.
Jalisi. Absent.
Absent.
Anderton,
Yes.
Gilchrist,
Yes.
Healy.
Yes.
Chairman votes yes. The bill, try and put it on a report as quickly as you can.
May we have a vote tally?
Oh, sure, yeah. Trish,
It's 18-5.
I demand a recount. Close one. Close one.
stop the steal. Okay. Okay, sorry, I shouldn't have said that. Okay. Any announcements, people?
Mr. Chairman,
Yes, Jim.
Ag Subcommittee in 10 minutes at 5:40.
Okay. Any other announcements? Vice Chair.
Thanks. Thank you, Mr. Chairman. The Environment Committee will meet tomorrow at 12:15.
Okay, who else? Holmes.
Thank you, Mr. Chair. The Housing and Real Property Subcommittee will meet tomorrow at 12:30.
Okay, any other DFH?
Thank you, Mr. Chairman. The House Motor Vehicle Transportation Committee will meet on Thursday at 12:15.
Okay.
At what time?
12:15.
Yeah, and we're gonna have double sessions probably all week. So, Ann, did you have an announcement or?
I don't, not at this time.
Okay.
Our meeting on Monday, yesterday.
Okay. Any other announcements from any members of the committee for the good of the committee or the bad of the committee? Okay, in that case, thank you very much. Meeting adjourned. Behave yourselves.
No.